Ladies and gentlemen, we kindly ask you to please take your seats as we prepare to commence.
Por favor, solicitamos a todos los asistentes que vayan tomando sus asientos.
Un, dos, tres. Probando. Yes, it's working. Understand? I thought that you want this. I connect you.
No, I want this.
Yeah, now it's working.
Yeah. Could I ask everybody to take a seat? Good morning. Good morning, everyone. Could you please take your seats? Good morning, good morning, good morning, good morning. Buenos días. Bonjour. Could everybody find their seats? Wow. I feel a bit like now. I am saying something and people are doing something in response to what I'm saying. Great. Good morning, everyone. Please take your seat. Welcome. Welcome to all participants. Welcome to all the speakers. And many thanks to the OECD as an organization and as an amazing people-centered team to bring us together yesterday, today and tomorrow. My name is Sam Muller. I'm your Master of Ceremonies today. And I will be walking up and down the podium to introduce people. My role will be to gradually try to distill the storyline that develops today. I think the OECD, the program, calls it the forward-looking vision that lies at the heart of everything that we do and that needs to take shape more urgently than ever. I will briefly be introducing each panel. I will be serving as timekeeper to ensure that everybody gets to speak and that we can have our lunch and our coffee and our tea on time. But let me just pause here for a minute. The starting point of this forum is that justice is the cornerstone of resilient societies and thriving economies. Let's just allow that to sink in as we start. Justice as the cornerstone of resilient societies and thriving economies. And I would ask that you really take that with you today, because that is why we are here. And for that to happen, our justice systems need to be more people-centered. And for that to happen, they need to be more data-driven and more innovative. They need to be a public service that undermines trust, inclusion, and sustainable growth. And we, ladies and gentlemen, participants, speakers, we are those justice systems. It's us. If we're not the change we seek, it isn't going to happen. A people-centered justice system that supports resilient societies and economic growth is not a closed institution, but an enabler of social cohesion, of competitiveness, embedded in a broader public governance and digital transformation agenda. And the OECD, over the past years, has given us the best possible best practices on how to do that. With the 2023 recommendation on people-centered justice systems, with the report that was published yesterday on responsive rule of law and the 4 strategic shifts that are being suggested there, and I wasn't there, but as I understand yesterday, with 50 high-level delegates and a really open, inspiring, valuable conversation on how to move forward. Today, we will be looking at AI, opportunities and challenges for justice systems. Somehow that's part of our story. We'll be looking at data and how data can help us make the change that is needed. We'll be looking at the economy and how can justice systems better support growth and competitiveness. And finally, we'll be looking at strengthening justice leadership in the complex interplay between the various branches of government. And we will end with some closing reflections. So let us get started. For that, we have a lot of wisdom and experience lined up. To begin with, I'd like to welcome Deputy Secretary General Mary Beth Goodman of the OECD for her opening remarks. Welcome. You have the floor.
Good morning, good morning, good morning, one and all. I love the enthusiasm in the room and no one wanting to take their seats because they're already having an exchange of ideas, and that's exactly what we want to see. It really is my pleasure to open the Justice Policy Forum on the second day of our roundtable and to engage with all of you who are leaders in this field, who understand that justice is not only a legal issue, but truly the foundation of economic stability and democratic resilience. Let me begin by once again thanking our hosts, the government of Spain, for all of their generosity and leadership, and also our partners who have really been instrumental with some of the support and work over the last 10 years. The Open Government Partnership, Pathfinders for Peaceful, Just, and Inclusive Societies, and of course, the Spanish Agency for International Development Cooperation. We've truly had steadfast collaboration, and we're grateful. I would also like to welcome and thank all of you, the countries, delegates, individuals who have been working alongside of us for the past 10 years since the first roundtable in 2015. We are meeting now at a time of, I don't even know the word anymore, right? We call it a time of global geopolitical instability, perhaps, but it really is more than that. When the democracy that we have counted on has been challenged to its very core in some institutions. And it is the public institutions that are being tested in literally every region of the world. We are in an age of polarization, misinformation, and economic uncertainty. People's trust in fairness and accountability has never mattered more. Justice systems are our first and our last line of defense for that trust. Yesterday's leader dialogue marked a turning point. Together, we celebrated 10 years of the OECD Global Roundtable on equal access to justice. And we looked ahead to the next decade, agreeing that we must double down on our efforts to ensure justice is people-centered, future-ready, and trusted. The new OECD report on making justice systems more effective and people-centered, and data from the World Justice Project reminds us why this matters. Globally, around 1.5 billion people have unresolved justice problems, with significant economic and social costs in our countries. Today, we must move from vision to implementation. This policy forum is where principles can become practice, where we translate our commitments into concrete strategies, measurable reforms, and collaboration that delivers results for people. Our discussions yesterday made it clear. Justice and the rule of law are essential foundations for prosperity and trust. They create the conditions for investment, innovation, and competitiveness, as well as social stability. And they reassure citizens that fairness and accountability are not considered optional extras. They must be guaranteed. Yet, OECD data shows that trust in government and in equal treatment remains far too low in many countries, especially among the most vulnerable. In an age of division and challenges, for information integrity, justice systems, these are not just only legal institutions. They are the anchors of democratic resilience. This is why the OECD's work on equal access to justice is embedded within the OECD's broader initiative on building trust and reinforcing democracy, which brings together integrity, open government, and people-centered justice as mutually reinforcing pillars of public trust. The leaders' dialogue provided a practical foundation for our conversations today, focusing on 3 imperatives for justice systems that deliver for people and economies. The first, making justice proactive and problem-solving. Too often, justice systems only intervene after problems have escalated. A future-ready justice system anticipates needs, prevents disputes, and resolves issues early, and where possible, informally. The report, Making Justice Systems More Effective and People-Centered, shows that people-centered justice can close a large justice gap, including everyday problems around money, consumer issues, housing, public services, and family matters. Our second pillar, embracing digital transformation responsibly. Artificial intelligence, automation, and data analytics can make justice faster, more accessible, and more efficient. For example, Spain's Justice Ministry has developed natural language and generative AI tools that classify, summarize, and translate judicial documents, including a legal to plain language function that helps non-lawyers understand court decisions. In Peru, the Amalta Pro system has reduced the time needed to draft protection orders in domestic violence cases from hours to mere seconds, dramatically improving timely protection for victims. At the same time, our work on governing with artificial intelligence and on justice data governance shows that technology only succeeds when people trust it, when they understand how it is being used, and when it protects their rights. Our third pillar, positioning justice as an economic enabler. Justice is a driver of productivity and growth. For small and medium-sized enterprises, accessible and predictable legal systems reduce transaction costs and encourage investment. The OECD's work on access to justice for SMEs shows how unresolved disputes with suppliers, clients, employees, or authorities can trigger massive income losses for these SMEs. Simplified procedures and targeted dispute resolution services can significantly reduce these risks. The conversations today on AI and data, on access for SMEs and judicial leadership will feed directly into the OECD's ongoing work on measurement, benchmarking, and implementation of the OECD's recommendation on access to justice and people-centered justice systems. Your inputs today will help build on the new OECD implementation toolkit for this recommendation. This recommendation and the toolkit will offer step-by-step roadmap for embedding people-centered justice across institutions and budgets. We are all stronger and able to deliver better results for our peoples when we collaborate and cooperate. Our goal today is to move beyond innovation and isolation, to move towards system-wide transformation by embedding people-centered justice in national plans, budgets, institutions, as well as in a growing global effort. Yesterday, we reaffirmed that justice is more than a right. It is a promise between government and people that fairness and dignity will be upheld both in law and in practice. Let us use this forum to turn that promise into action, to build justice systems that are proactive, efficient, and trusted because they deliver fair outcomes in people's lives. By doing so, we will strengthen not only our justice institutions, but the foundations of democracy, of prosperity, and of trust itself. Thank you very much for being here. Thank you for your collaboration, and I look forward to our fruitful discussions today.
Thank you very much, Deputy Secretary General. I would now like to give the floor to you, Manuel, State Secretary for Justice, Ministry of the Presidency, Justice and Parliamentary Relations of Spain. Welcome to the floor.
Thank you, Sam. Thank you, Mary Beth. Buenos días a todos.
Good morning, everyone. And thank you. I appreciate the efforts of the OCDE for co-organizing this roundtable with the government of Spain. This 10th edition on roundtables on building a justice public service that earns trust and delivers shared prosperity. Also, thanks to our partners and to all the delegations for making that effort of taking a break from that daily work that is sometimes overwhelming and devoting a few days to be here. Because that means when you go back to your office, you have a big backlog of things to do. And for that, I'm grateful. Because I sincerely believe that these face-to-face meetings, along with other types of communication that we can now apply as part of our normal day-to-day, like video conference and text message, create a true interaction among individuals and people that together create working networks to overcome what we have seen are common shared problems. I am here to tell you about a project that started during the world pandemic lockdown at the Ministry of Justice from the Spanish government. At that point, the program was called Justice 2030, and it had a 10-year action plan from 2020 till 2030 to tackle the largest transformation of the justice system to take place in Spain in decades. At that time, we were contemplating the future of justice, and of course, the first step was analyzing the situation of justice in Spain at the time to run a diagnosis of the main problems, many of them shared with other countries, some of them endemic, if you will, which had to be addressed very specifically. And it took courage to implement the treatment to that diagnosis in a context that tends to be reactive to change. Justices are reactive to change. We, as judges, are reactive to change, unless change is printed in the law. Because as judges, we have the habit of implementing decisions made by others and apply the legislation, apply the law. Maybe I need to remind you of the context at the time. We live in social democratic rules of law that rest on precisely the rule of law, the protection of fundamental rights, and the division of the state powers, executive, legislative, and judicial, which are interconnected via a set of check and balances to mutually control one another. At the same time, democratic states apply the rule of law very specifically thanks to the popular opinion of citizens when they vote their public servants, always considering respect to minorities and those who think differently, because no democracy is complete unless they have a vision to protect minorities. And the context also includes a social component. In this context, justice has a teaching endeavor to foster tolerance, respect, and compensation for the breach of citizens' rights. In this sense, we approach the digital transformation following 4 fundamental lines. First, a legislation transformation, an organizational transformation, a digital transformation with the implementation of new technology solutions, and fourth, a will to set up a new perspective in conflict solving, not only in court, which is, as we know, a fundamental citizen's right, but also in other fields with equally appropriate solutions like mediation, conciliation, negotiation among the parties, restorative justice in the criminal field that may help or assist conflict resolution to the full satisfaction of the parties involved. On the normative side, we have administrative efficiency, digital efficiency, and procedural efficiency that are already part of our legislation and published in the official documents where the laws approved by the Spanish Parliament are published. And at the same time, we're introducing some elements of soft law. I will mention 2 of them. First, the data manifesto, as we call it. This is a consensual document between the judiciary power, the General Attorney's Office, and the executive power, not just the national executive power, but also the local executive powers. Spain is almost a federal, highly decentralized system where certain regions, autonomous regions, have a say in the legislation. And in that sense, there are co-governance aspects where we can make progress. And it's a complex environment because of the huge amount of actors involved and institutions that do have a say on the matter. That data manifesto considers data as a public good. So it regulates the use of data. It bans the excluding use of data. All of this with the ultimate purpose of generating better public decision-making to enhance the public service of justice. The manifesto is available on our website, both in English and in Spanish, if you are interested. Beyond that, the data manifesto is a policy for using AI as applied to justice. Spain is an EU member, so the document is fully in sync with the European Act for AI, but this one contemplates the specific field of justice. Obviously, the principles of fact, fairness, accountability, transparency are fully respected under the manifesto, and it is addressed not only to public justice stakeholders, but also to AI suppliers, so that they can be aware of the implementation context of artificial intelligence in justice. And We don't want to be the spearhead of technology. We don't want to be the fastest and the bestest in implementing AI, no matter the price. Our context, our mandate is very specific: the full protection of individuals' fundamental rights. These days, we're celebrating the 75th anniversary of the Rome Convention in Europe. But we could be talking about the Universal Human Rights Compact or the New York Charter and all the documents protecting the rights and freedoms of individuals. And new technologies, particularly AI, can only be applied to our systems if we fully respect those fundamental rights. There are probably other regions in the world that have a different approach. Our approach is this: we put people first. Any new technology or development is meant to enhance the lives of people and shrink the existing gaps, never to create new gaps. So that's the first part of our strategic transformation project. That's the standard transformation. Second, a digital transformation within the same concept I just described. And we've discussed several technology solutions that I find interesting. Many of these have already been adopted by other countries. There are other newer, bright examples. But the first step is having a procedural management system that is fully digital and fully data-driven, so that not only courts of law can communicate amongst themselves automatically and with a data-centered perspective, but also they need to communicate to other administrations and procedural administration systems from other countries. In some cases, we can now work document-free, just following data schemes or data flows. Just as an example, there's a procedure in Spain. It's called a monitoring procedure for debt collection. It's a process for financial claims that seeks to a fast decision if the debtor does not appeal to the decision. Today, approximately 60% of the work of civil courts is devoted to these procedures. Up until now, the filing of a claim within this process took 2 to 3 months just to put the document on record and allocate it to the judges assigned. Thanks to our data-oriented system and thanks to the approval of standard models that are compulsory by law, new lawyers are filling in these forms, going into our procedural management system automatically, and the cases are sent to the case for investigation on the matter. What used to take 2 to 3 months now takes 24 hours. At the beginning, attorneys were saying, well, we're actually doing the court's work. But now everyone is very pleased because on the very same day, they can tell their client, your case has gone to judge number such and such from the Madrid Court of Justice or from Barcelona. So the response time has been reduced impressively. Of course, a human has to participate to make the ultimate decision on whether the claim is acceptable or not. But all the paperwork with little added value that was just about punching data into a computer is now being done virtually automatically by a machine. Important disclaimer here, though. If the case is filed by a lawyer or a company, they're mandated to do so electronically. But if the case is raised by a citizen for smaller amount claims, citizens have the right to communicate with the court either online or through the traditional method. So we're bridging gaps, not creating new gaps. Some people are just not digitally savvy enough to deal with these matters. So they're allowed to work traditionally. Another example, the Justice folder. It's a folder called Justicia. Thanks to this folder, both professionals and the involved parties in a procedure can see perhaps not the exact map of the proceedings, but all the steps, obviously under a consultation view. It's like a query possibility, just as these steps would be seen by any public official. So in real time, a citizen can know the status of their proceedings and the different steps followed, except if the judge has declared secrecy for any reason. So that's one more step in generating trust among citizens, because they can have direct access. They can already do so in the health system. A patient can see their x-rays and their health status online, and the visits they have made to their family doctor. So why not do it in the justice system? They might not understand a ruling because they don't speak legalese, but as Mary Beth said, we have an app to translate from legalese to natural language for those who are not savvy in legal matters, or for those who are not fully understandable. As judges, we sometimes write very complicated sentences. And also, we have an easy reading system using pictograms for people with some sort of cognitive challenge. In other words, not just plain language, but also easy reading for everyone.
Un último ejemplo.
Just the last example. How is data open to the public in justice? We have a website, data, and of course with certain limitations. We have published for the citizens a huge number of data collected by the justice system. So academics can use it, but also the public can know about the situation of the justice system in their country. On top of this, and this is going to be really the last example, because I wanted to share another one also, is the automation of certain processes. I mentioned the small money procedures, but we have the deposit accounts of the courts that have an average balance in Spain of 5 million euros, with entries and exits of hundreds of millions of euros. Somebody that has to pay a pension to their children or former partner, and they do it through these deposits accounts at the courts. All those movements were carried out manually. Every month it was the same movement of paying the pension. Thanks to the automation of these processes and being data-driven, all those transfers are now automatically saving thousands of hours of work from public servants that can now devote to a more added value task. Therefore, technology solutions that enhance people's lives and also the protection of rights that help people in their economic activities, especially the smaller ones that are the majority of the economic and productive fabric of Spain, where SMEs have an important weight in the functioning of the country's economy, and sometimes they don't have the resources to access justice system in such a simple manner. Regulatory transformation, technological solutions, and thirdly, organizational transformation. That was an endemic problem in Spain. The way we organized ourselves came or dated back from 1834, with small offices, small courts, very little civil servants. So specialization was not possible, either flexibility or adaptation to modern or mass litigation. the large law firms, they use automation and artificial intelligence tools to litigate, and the justice systems needs to be ready for this. We have changed our former organization, replacing our old courts into first instance courts that are modern, flexible, specialized, and can meet the needs of the citizens today. And on the other hand, in this idea of overcoming the bridge, the population living in large cities from those that live in remote and rural areas, and in Spain there's a great imbalance between the coast and the big cities, and in inland Spain, rural deserted areas, we've been using the first instance courts in small villages with small functions, and thanks to IT and video conference systems, now in all those offices, now we can offer the population living in these remote or depopulated areas a full catalog of justice services, which is much better than the one they had before. So they don't have to go to courts unless judges, due to the seriousness of the case or due to some exceptional circumstances that are all in the law of legal security. And in some cases, they might have to go to court, but in majority of cases, they can connect to the court through video conferencing systems to check that an invoice is okay or the amount is okay, to accept a divorce process without underage, those things that they could not do until now. This is the organizational transformation that for us is really important. It overcomes the gap between rural and urban population. And lastly, the promotion of a culture of agreement. As I said at the beginning, many of the conflicts among people or companies and firms have a solution in the courts, but many others could be channeled to other alternative systems that are also fit for conflict solving and allow the parties to be an active part in solving their own problems. This is mediation, conciliation, but also direct negotiation among the lawyers. This is what they have always done. But now we've changed the paradigm in the civil and mercantile domain, with some exception of very delicate procedures. It is mandatory to go to an alternative channel before going to the civil jurisdiction, and the courts will also analyze the attitude and behavior of the parties in trying to reach an agreement that would avoid the conflict going into the judicial or legal system, since there might be an abuse of the use of the justice system that should be limited when there is not an alternative solution. This is what we're promoting, introducing in the Act those alternative modes for conflict solving. We had a plan, we still have a plan. We analyzed the problems, we made a diagnosis of potential solutions, and we implemented them through a regulatory transformation to change the way the courts function in our country, incorporating new technologies and a new culture of agreement, always focused on humans to protect people's dignity and their fundamental rights. This is what we are, and this is where we come from. We are a democratic state. We're a social state that protects their citizens, promoting tolerance and agreement and understanding. There's still a lot to do. All this transformation is a process, but we know where we're heading, and thanks to everyone's collaboration, of all of you and the OECD, and we love to work with them, we know we are on the right track. Thank you very much for your attention, and my team is available, and also myself, to sort out any possible doubts or questions you might have. Thank you.
Wow. So that's how you do it. Easy peasy. Okay, so the State Minister spoke of digital and how important digital is. I'd now like to introduce Margaret Hagan, who's the Executive Director of the Legal Design Lab of Stanford University. And she will, I think, blow our minds on the digital. She will share with us levels of AI strategy, different levels of complexity, and how you do it. Please, Margaret, you have the floor.
Thank you so much. Hello, nice to see you all. So I'm Margaret. I'm going to be talking today about the future of justice, and especially about this particular moment in time. Right now we are at this strange point. I don't know if any of you can guess what happened in November 2022, 3 years ago. Anyone not in Silicon Valley remember when ChatGPT first was made public? I probably heard of it not right then, maybe December. I heard from younger people at my university, have you tried this? This is going to destroy Google. This is amazing. I think we all know, probably by around January, February of 2023, news articles, coverage, even in legal journals, ChatGPT, generative AI, what does this mean? Especially for knowledge workers, legal, consultants, financial, medical. And we see, I think here I would put that line as the excitement and hype, not necessarily the delivery of real value or accomplishment in people's lives, but the amount of discussion and excitement about will this new era of AI, of generative AI, really deliver transformational value. Right now, at November 2025, 3 years in, I think many of us are still up at that hype cycle. I'm coming from Silicon Valley in California. The whole economy is riding on the hype cycle of AI. Of course, though, we have the confusion, and especially for those of you in the room who are the justice system, who are thinking about our institutions and our public. How do we actually make a justice system that is fair, efficient, and effective for the public, when what the justice system is profoundly being affected by AI? Whether we, in organizations like law schools, justice institutions, legal aid groups, courts, are not really in control right now. What the public does when it comes to AI is not being dictated by central organizations. And we are at a moment in time, I think that it's essential to think about strategy. If those of us inside of justice organizations don't want AI to happen to us in that reactive stance, as mentioned before, but how do we make an intentional strategy right now before AI takes over even more, so that we are in control, as much as we can be, of what the next 5 to 10 years of justice system transformation looks like. I'm coming from the US perspective, and when I speak to my colleagues in court administration, in legal services, in local government, and in the federal government, there's a lot of discussion about what AI means. A lot of it is inward focusing. For our organization, for our court clerks, for our judges, for our lawyers, for our officials, should we be letting them use AI? Should we be building things in-house or buying them from vendors? What's our strategy? Or we've tried to build AI, but we can't actually get it to be very accurate or reliable. And that's wonderful. We need to have these discussions about internal, what we can do and what we're in control of inside of our own organizations. But I'm going to argue here today that we need to go beyond just thinking about AI inside of our legal organization, our court, or our legal aid group. Because the system is moving on and the public is moving on, whether we like it or not. And I'm going to argue to you and hopefully engage you in thinking about 3 levels of AI strategy. And I'll take each in turn. But for those of us who want to have good outcomes in our justice systems in 5 years, by 2030 in November, or 2035 in November, 10 years from now, How do we get to that better system that is more fair, more effective, and more people-centered? The first, and what I'll talk about first, is this internal AI strategy, what we're in control of, what we can do inside of our own organizations. Second, though, I'll talk about an ecosystem strategy among our organizations. In the US, among our state courts, among our legal aid groups, and maybe even among legal aid providers and courts, perhaps even internationally. And the third level of strategy is recognizing that we're actually quite small in our justice sector, and we are surrounded by large and growing technology companies that are increasingly playing a central role in the public's life and public's problem solving, and also are at the core of any new technology we build is going to be dependent on these large companies and how we can start to have some strategy towards these large external technology companies. All right, so let me take you through these three strategies. The first one, and I'm guessing that most of you have already engaged in this level of thinking, what we can do inside of our own organizations. So at the lab I run at the university, we work as an R&D, research and development partner to many legal organizations. We have partnerships with the largest trial court in the country, LA Superior Court in Los Angeles County. We work with many service providers like legal aid groups. And when they're thinking about AI strategy, how to unlock value responsibly, I would say the default go-to, at least as of the past year, for most courts and legal aid groups, is thinking about, can we give our team members who do housing law or triage or administration, can we give them a license to something like Microsoft Copilot or ChatGPT Enterprise and have them try it out? And maybe we'll write an internal policy that gives them some direction about what they can or cannot use AI for. This strategy has not proven to show real results. We cannot just give people a license to AI inside of our teams, give them some rules, and hope that this transformation is going to happen. We need to think more fundamentally about how we want our next 5 years of justice system to actually look. We cannot just give AI and see the transformation happen. We need to take that people-centered look. We need to see for our housing team, who's either overseeing housing court or trying to help landlords and tenants with their problem, or employment legal people, helping employers or the public with their employment law problems, people in operations and administration of the organizations. We need to be going deep with these different teams and prioritizing actually what does that new version of providing services or managing cases look like? Not just how to add AI into one bit of it to make one process 2 hours more efficient. We need to be thinking about what do we actually want the future of our services to the public to look like. We need to also be thinking, like engineers, very process-driven about what we can make the new day-to-days of our team members and the public look like. So let me give you some more details. This service innovation lens is looking at what do our housing law, operations, employment law, consumer law, our various teams, what do we want the interaction with the public to look like in 2030? Not just how do we make the current service better, but can we come up with ideas in each of our specific teams about what that better service that is more efficient, more user-friendly, less costly, how do we actually deliver more value to our members of the public and have better policy impacts? And that means rethinking how we deliver services through AI, not just putting AI on top. And it also means thinking very specifically about what do our lawyers and our administrators, our judges, actually do day to day. This is what I do a lot of my time when I'm coming to an organization and helping them make an AI new pilot, is I actually talk to the lawyers and paralegals, judges, what do you actually do all day? Let's go through and say, when you have a housing law case, what are all the steps you go through? What do you wish it was like? How could we transform this? This can help us think both where AI can fit, have those kind of light bulb aha moments of, oh, could we cut out those steps or could we delegate to AI to do these specific things? but also maybe we can make this 10-step process into 2 steps. How do we really transform this? So we have to think very pragmatically, very practically. And so this is what I often tell to my clients or partners, courts or legal aid groups. Oftentimes they're coming in almost with magical thinking. We just get generative AI, we snap our fingers, and then everything will be easier and faster and better. That's kind of what the hype cycle of the news thinks. Actually, it takes a lot of work in the middle. This is what usually takes somewhere between 8 months and 16 months of talking to the teams, brainstorming ideas, getting very specific about where AI can responsibly help, doing a lot of data work, inventorying all the data, preparing the data, testing out if the different AI models can actually perform, setting very specific evaluation and quality benchmarks, going through rounds and rounds of iterative, agile design. Just like any of you who have been on a digital transformation project, these things take time, a lot of effort, and a lot of staff. But the investment can pay off. If we go through these, and I would recommend to you to, as you go back home next week, if you can work with your specific teams and find 1 or 2 specific workflows to develop a new AI pilot, so not just buying a license to a Microsoft or OpenAI or Google product, but really digging deep and transforming how you deliver that service. It will take an investment, but that is where we can get real value from AI. So for example, in my team, we're working a lot on housing. We have a housing crisis in America, like many other countries. So we're working both with the courts and the legal aid to transform very specific workflows. How they help clients fill in a specific document in eviction court, or how they triage and route different kinds of landlords and tenants. So we have gone into the housing law team, picked very specific workflows, and then going through this very deliberate, but hopefully people-centered and quality AI piloting. And you can see I've talked to many other organizations. This is more US-based than international, but you can see more projects where people have chosen specific services to transform and then gone through this AI R&D process. So each organization, this is kind of the first level of strategy, is all about getting concrete. Not just buying an AI license, but really dedicating resources to specific AI pilots. Level 2. So beyond what you can control. And this really, I think, is especially important with AI, to think about how we partner and share across organizations, across borders. And this is, I think, a point that's going to be reinforced throughout today. To actually build, but then especially to maintain AI solutions is very, very demanding of financial, staff, compute power. This is a lesson that we're learning as we're going through and developing more AI pilots. This is not a typical technology transformation project like you might have done with creating websites, case management systems, document assembly systems. That first era of technology innovation in legal, from about the year 2000 to 2020, you could create a technology project in a lab, test it extensively, roll it out with the public, test it some more, but then be confident that it will behave. It will follow the rules, and you can estimate how much it's going to cost and how to protect people. AI is a different kind of technology. It requires maintenance and constant evaluation. Even if it works in a lab, even if it works in a controlled pilot, is not a guarantee that in 1 year it will behave the same way. What we've seen in medical AI pilots is that a clinical support system to help doctors and nurses diagnose patients may work very well in the year 2022, but for some mysterious reason by 2025, its accuracy rating goes from 99% to 90%. It starts to slip. We need to build a new kind of rollout for our AI systems that is constantly evaluating and making sure that its accuracy rates are not slipping in the same way. That requires a lot of money, data, and human capacity. First of all, I'm sure you all know that licenses to AI and compute power are extremely expensive. If you want the best-in-class AI, you will pay a lot of money to the big technology companies for it. It also is incredibly hard, I know this in the US, in our highly federated system, to get good data. And good data is going to be the essential ingredient for high-performing AI. That requires a lot of time, negotiation, and people to actually get the data in shape to build great AI. We need wonderful team members who are very skilled at AI development and evaluation. We need time to actually develop the AI on those 12 to 18-month cycles. We need to invest in really smart privacy and safety protections from the beginning. And we need to be constantly evaluating, not just in a qualitative way, but in a quantitative, rigorous way, whether the AI systems are performing up to our benchmarks. That all requires lots of capacity. And this is where we can think about an ecosystem strategy. Instead of each organization, each court, each legal aid group, each ministry doing this on their own, what can we do together? What can we share across borders? So can we do any of these things together? Are any of these things possible? I think the OECD is already laying the groundwork for this. I know we'll talk about it throughout the day. In the United States, we are thinking about this. Can we have group licenses or discounts with our big technology companies that we must spend so much money to get compute from? For data, can we have more data standards, more data stewardship, more common knowledge bases? To really unlock the human team members, to have people with the skills, can we invest in shared trainings of our existing staff? And maybe even shared capacity of those very expensive AI developers that have very high salaries in the US? Can we share some of that with things like strike teams or common team members? Once one team in one organization spends 18 months building a very high-performing AI agent, is there a way that another team in another country, another county, another court can borrow that agent? Instead of having to do another 18-month cycle, can we share a lot of the IP or playbooks to shorten the development cycle in other organizations? For safety and privacy, can we have common ways that we are all using the same standard to mask personally identifiable information, to have better guardrails and disclosure designs, to have pattern libraries so we are not all having to reinvent that wheel? For evaluation, it's so important to be investing in benchmarks right now. And in AI, that means something special. That means a data set with what are the inputs, what is being asked of the AI tool, and then the outputs that are either good or bad and labeled with scores. And they're almost like standardized tests that you can give to the AI developers, to OpenAI's development team, to Google's development team, to Anthropic, or to Meta. It's almost giving like for us, a SAT or an LSAT or a bar exam to these models. It takes a lot of time to invest and build these benchmarks, but once they are out there, they can be a great way to automate the evaluation of the performance of these technical systems. So I don't have the answers here. We have a lot of hypotheses, but hopefully throughout the day, we'll talk more about what we can share among each other. The third level, what's even the least out of our control, but I think so essential. How do we, in the justice sector, have a strategy towards the technology companies that are holding these foundation models and also holding the central relationships with the public? We are a small blip. I am constantly reminded of this. I go to a lot of conferences in Silicon Valley, so I'm talking with policy team members and developers from the large companies that are building the foundation models at the center of all of these transformations, and who are also the front door to the internet for so many people, who are increasingly building relationships with ChatGPT, going to it for all of their problems, whether it's mental health problems, medical diagnosis problems, schoolwork and knowledge work problems, and yes, legal problems. From what OpenAI has released about how people are using ChatGPT, we see legal problem solving all over it. And no matter what is in their terms of service of please do not use this tool, it is not your lawyer, people are ignoring that, and they are finding their way around any guardrails that the technology companies put up. If you go on Reddit and see people's reports about how they solve problems right now, it's about taking photos of any legal document they get, uploading it into ChatGPT and saying, what should I do? Tell me, help me write a letter, tell me what clauses in this lease are illegal, tell me what I should say in front of the judge. These tools are increasingly being the place where people go to for help and advice, rather than to justice organizations. Of course, that's not everyone. I'm not speaking for the entire public, but we are seeing this profound shift in consumers' problem solving. This is AI happening to the justice system and us in a reactive mode. The other thing we see happening is that developers, people who are building solutions, including in our own organizations, have to build on top of OpenAI's model, Google's model, Meta's model, Anthropic's model. Because they are investing billions of dollars in the most cutting-edge AI, none of us can build our own AI that can compete. We have to build on top of their systems, on top of their models, or on top of their platforms. That makes us incredibly dependent on them. So whether it's what OpenAI will show people when people chat with it on ChatGPT, or if we have an AI system on our own website, we are still relying on OpenAI's models often to be the brain behind our model, our solution. So the question for all of us is really how we can shape these few but mighty technology providers' role in the justice system, both in terms of their growing relationship with the public, but also how fundamental they are to whatever AI we develop. Again, I have no perfect solutions. I have been talking with as many of my technology company colleagues, whether it's at the vice president, executive level, or the folks who work day to day building these models, testing them, and releasing them. Many of them are my former students. Many of them are young people in their 20s and early 30s. They don't necessarily know the answer. They're getting lots of similar calls and requests from people not in legal, but from medical, from mental health, from government, from every other sector. So we as the justice sector are one little blip with all of these other groups also being disrupted by AI at the same time. But there are some ways to engage with technology companies, either in the more collaborative or in the more challenging ways, to see how we can make sure that their models are both serving the public in the most fair, effective, and protective ways, but also high performing for the legal needs that we needed as we build our AI solutions on top of them. Some of the things that we can work with the big technology companies on are how they build guardrails into their products like ChatGPT, Google Search or Gemini, Anthropic's Claude, Meta's WhatsApp AI, but really working with them to understand what the risks are in legal, what can go wrong, what harm looks like, and how they can build, whether it's disclosures, official guardrails where their models will not talk to people about certain ways, or better ways to understand and build those protections into their consumer-facing platforms. That also involves things like red teaming. So really pushing the boundaries and seeing where do the models get it wrong in real life. If we try to be as adversarial as possible or put as many problem situations, can we start to measure and capture when these systems are actually doing real harm? So less speculation and more data-driven harms research. And helping that inform better policy and better guardrails. In the more collaborative side, there are ways to sit down, both with the executive level, but also the implementation level of teams working at these technology companies. Educating them, honestly, this is what I do a lot of the time, is have coffee with engineers who are building or testing these models and try to explain to them what the justice system is, what kinds of problems people are coming to in the justice system, and what good and bad outcomes look like, helping them even understand our sector. And then thinking about, like they are developing with health, having officials from our sector present in their discussions, in panels who oversee their new releases or their new products, who are in constant discussion about how their new model or new feature might be affecting our domain. A real incentive and a way that I've seen actually have tremendous pressure and results on especially the developer level of the models is to publish things like benchmarks. And again, these are the quantitative data-driven benchmarks, a standardized test for the models. As a team at a large technology company, every 2 weeks is releasing updates to their models. They put them through a battery of tests to see, is this model ready for the public or not? We don't really have any legal tests that they are putting them through. They run them for medical misinformation, they run them for mental health problems, but we don't have any really well-formed benchmark for them to run their new models through to see how they perform on legal tasks. When there are leaderboards published as well to say, here's where OpenAI's model ranks on these tasks versus Anthropic's, versus Google's, versus Grok's, versus Meta's, that's a real incentive. That can be a positive pressure to say, your model is performing at a very low score on legal tasks that we know matter to the everyday public. Here are the tasks that you should be training your model to do better. Can you get your position on the leaderboard to raise? This is kind of a central way that developers are anchoring whether they're doing a good job on their models or not. And finally, we need to think about the harms. We know, we know that people are using these tools both at things like ChatGPT or Google Search or on legal organizations' own website. We need to be prepared for mistakes to happen. There is never going to be a 100% accurate AI solution. We have to prepare for the risks that we know are coming. So whether that's with consumer mechanisms for them to raise claims, be heard, and then be made whole, whether it's through insurance or other strategies, we need to have ways to prepare for the harms that we know are going to happen. It's part of the deal with generative AI. So I've taken you through the 3 levels of strategies: the internal, what you can do inside your own organizations; the ecosystem, what we can be doing, sharing among; and then thinking about the external and how we relate to big technology. My hope is that if we meet again in 5 years, we will have those clear strategies laid out for our own organizations and as an ecosystem, and that we'll have seen progress, and we can be optimistic about the future. You know, as a Californian, I really do want to be optimistic. But I'm very happy to discuss with you afterwards if you have ideas or if you're already working in this way. I think in the United States, we're trying very hard to take this collaborative approach. And I'll just say thank you very much for your attention. Thank you.
Thank you, Margaret. You've just opened a completely additional new world universe for us, as if people-centered justice in and of itself wasn't complicated enough, but this is very, very enlightening. To close this foundational session, I'd like to ask your attention for some remarks by Richard Susskind, who is the advisor to the Secretary General of the Commonwealth on AI. He's done a lot of AI. He's written a recent book on AI, which for people who don't know much about it, like me, is very good and very enlightening. He will address us in the form of a video.
Good morning. My name is Richard Susskind. Thank you very much for listening to me over the next 15 minutes or so. I'm sorry I can't join you in person, but personal circumstances have meant that I need to speak to you remotely. But the subject I want to talk to you about today, I think, is extremely important, and it fits very comfortably into your broader theme of equal access to justice. The subject I want to talk about is AI. I want to say a little about the mindset you should have in thinking about AI, explain a little bit of the common trends we're seeing in the technology, and then identify several different ways of thinking about the future, different hypotheses about what AI might hold for us. And then in concluding, I want to say what all of this means for law and courts and justice. Let me start with mindset. One of my favorite stories in life is about Black & Decker, who manufacture power tools. And apparently when they recruit new executives, they take them off on a course and put up a slide of a gleaming power drill and say, this is what we sell, isn't it? And everyone agrees. The trainers, with some satisfaction, put up a different slide. And they say, this is actually what we sell. And the new slide depicts a hole neatly drilled in a piece of wood. And they say that's what our customers actually want. That's what we actually sell. And it's your job to find ever more creative, imaginative, competitive ways of giving our customers what they want. And I think there's a vital lesson here for all of us thinking about the future of justice and legal and court services. Too often we tend to think, well, how do we do it today? What's the power drill today? The way we tackle justice problems? And how can we make it cheaper, quicker, or better? What I want you to think of instead is the hole in the wall. What's the hole in the wall in your world? What's the fundamental value you bring to those we serve? And might we bring that value in different ways in an AI-based world? So that's my first mindset challenge. My second mindset challenge relates to a distinction I draw between automation and innovation. Automation is computerizing what we already do. And the first 65 years of court and legal technology was devoted to this, to grafting technology onto our existing ways of working. Innovation, in my terms at least, is something quite different. It's about the use of technology to allow us to do things that previously were not possible. And for me, that's the great excitement of AI and digital technology and law. It's allowing us to meet the access to justice problem, to enabling wider and equal access to justice in new ways. Not simply computerizing what we already do, but using the technology to allow us to provide a richer, deeper, wider service. And the third question of mindset for you is simply a question I've been asking for the last 20 or 30 years. Is court a service or a place? Do we really need physically to assemble together on all occasions to resolve all problems? Or in a digital world, might we find different ways of handling disputes? So there's the mindset issues. Think about the power drill, but think more of the hole in the wall. Think about automation, but think more of innovation. And ask yourself, do we really need always to congregate together? Let me say something about AI. Remarkable technology. I date it since the 1950s. I wrote my PhD on AI and law in the 1980s. But at the end of November 2022, something remarkable happened. It was the launch of ChatGPT by OpenAI. And suddenly, for lawyers, here was a general purpose tool that could summarize documents, draft documents, compare documents, visualize documents, analyze documents, produce kinds of legal arguments, conduct legal research, answer legal questions. Now, then and now, I accept that these systems make mistakes. They're absolutely not entirely reliable. But we never anticipated just a few years ago that we would have these general purpose systems. It was the most remarkable single development I'd seen in 40 years, and not expected by most computer scientists who had said that AI would be narrow for decades, yet only working in very specific domains. But one of the main messages I have to you today is that generative AI, which is what everyone is talking about, and ChatGPT is the best example of this, generative AI, these systems that can generate apparently meaningful language and videos and music, and even can write software, generate code, this is simply the latest chapter in the ongoing story that is AI. Generative AI, what we have today, is not the first chapter. AI was not born a few years ago. It's assuredly not the final chapter. In fact, I believe, and it's a main message for you today, that we're simply warming up. Because the underpinning technologies in AI are growing at an explosive exponential rate. To build today's systems, we use computing resource. And the more computing resource we can apply, the better the systems perform. Computing resource is doubling every 6 months, computing power. And that means over a 10-year period, we'll see 20 doublings. The mathematicians amongst you will remember 2 to the power 20. That means a 1 million-fold increase in the computing power we'll have available to build these AI systems, even if we have no further developments in the AI technology itself, because there's no finishing line here. No one in Silicon Valley or China is dusting their hands off and saying, job done, we've finished with AI, let's move on to something else. Quite the reverse. The pace of change is accelerating. So the big question we all have to ask in law and justice and elsewhere is, where are we heading? Where's this all going to lead? And I've recently published a book on this called How to Think About AI, A Guide for the Perplexed. I think we'll all remain perplexed for some years yet. But what I wanted to clarify was the main thinking about the future of AI. And immediately we confront a difficulty. The AI community does not speak with a single voice about where AI will go. So one hypothesis is that AI is actually hype, that the systems today are only superficially impressive, but they suffer from biases, they hallucinate, they make mistakes, and in a couple of years, the bubble will burst because these systems won't be economically viable because we'll have to have human beings always supervising and correcting them. That's one view. A second view is that the generative AI systems we have today will in a few years' time become entirely reliable. So much is being invested, the systems we use rightly with caution today, because they make errors, will in due course be entirely reliable. A third hypothesis is known as the AGI hypothesis, artificial general intelligence. And this means that AI systems will at some stage match human performance across the full range of our cognitive tasks. They'll be as capable as humans. This might sound science fictional. Some research was undertaken in the middle of the 2022, just before ChatGPT was invented or launched. And it asked leading AI developers, people who build these systems, how long before we have AGI? The answer then, the common answer, was 20 to 40 years if ever. You ask that same question today, and these AI developers will say 5 to 10 years. Now, if this is the case, this constitutes, in my estimation, the single most important development, technological development in human history, that we'll develop systems that can perform at the level of humans. And the impact on access to justice is profound. It will cause us to revisit all sorts of assumptions about how we spread knowledge of the law and how we resolve disputes, for example. The fourth view is that we're actually not going to stop at AGI. We're going to have superintelligence, that we'll have systems that outperform us, that are much more capable than us. Now, which do we believe then? Is it all hype? Will we get to the stage where today's systems will be reliable, but no more? Will we achieve systems that perform at our level? Or will we even have systems that outperform us? How do we think about this? Well, the first thing is we have to distinguish between the advance of technology and the adoption of technology. So even if the technology advances explosively, exponentially, there are all sorts of reasons why the technology may not be adopted. Regulatory, cultural, economic reasons. I also want to warn you against a pitfall, which I call not us thinking. I find when I do research across the professions that everyone finds far greater scope for AI in professions other than their own. Now, this we have to see as slightly irrational. Does it seem right that somehow AI will apply in all walks of life except yours? That seems to me to be improbable. Avoid also the pitfall of technological myopia, looking at the future potential of technology through the lens of today's limitations. There are problems today, but if you look at the scale of investment, it's likely they'll be overcome. So how do I think about the future? What guides me? Well, I look at the trajectory of the breakthroughs. In the early days of AI, breakthroughs came every 5 to 10 years. They're now coming every 6 to 12 months. I look at the way our machines are doing more and more. I look at the explosive growth, as I mentioned, in the underpinning technologies. I look at the way the AI systems are being used to generate the next version of AI systems. I look at the scale of investment, more investment in AI technology than any single technology in history. I look at the evident market demand, governments and businesses interested, even in today's AI, for productivity and efficient improvements. I look at the remarkable energy of tens of thousands of startup communities. I look at how many able humans are involved in AI, and I say to you that the hype hypothesis is implausible. There simply, in my view, won't be a roadblock over the next couple of years. And to assume the future of AI and justice on the basis of the hype hypothesis, I believe, is to commit a dereliction of duty. I predict by 2030, the systems we have today, the kinds of systems, ChatGPT and the rest, will be entirely reliable for most purposes. My bigger point is I think we need to plan for AGI by 2030 to 2035. I'm not predicting that, although many others are, but so profound would its impact be on law and justice that we at least need to be thinking about that today. So what does all this mean for the legal world, for the justice world? I find it amusing in person when I speak to audiences of lawyers and judges, people say, well, hang on, what does this mean for lawyers? What does it mean for law firms? What does it mean for judges? Isn't it interesting when there's a breakthrough in medicine, we don't ask the question, what does it mean for doctors? We ask, what does it mean for patients? And so too, when we're thinking of the future of justice, we need to be far more citizen-oriented, consumer-oriented, court and dispute resolution service user-oriented. For too long, we've developed dispute resolution systems by lawyers for lawyers. We now need to think about how we can harness the great power of AI in developing systems that are actually focused on the needs of actual court users and dispute resolution system users. I would say to you, though, that I think a lot of the short-term predictions about AI are hugely overstating its impact on AI. For the regulatory, cultural, and commercial reasons I mentioned, I don't think we'll see a transformation in courts and justice services over the next 2 or 3 years. But I do think the long-term predictions, funnily enough, are hugely understating its impact. So I think as we move into the 30s, so we've got time to prepare, we'll see a radical change in the way we can deliver court services. In the short term, we'll see AI used by lawyers and other legal and justice professionals to automate what they do, to make them more efficient and productive. In the long run, it'll be about what I call innovation, fundamentally changing the way we deliver services. Above all else, AI not as a new tool for lawyers, but AI to empower citizens, to empower organizations. So 3 things to look for in the justice world: online legal guidance, systems that are very high level, help people understand, assert, enforce their legal entitlements. Secondly, AI for early resolution, a kind of early neutral evaluation done by AI. And thirdly, and most controversial, and we need to discuss this, AI as a way of providing some kind of determination to disputes. People ask, can computers replace judges? I don't think that's the right question. I think there's 3 better questions. The first question is, can the state provide alternative online dispute settling services? Not replacing judicial services, complementary services. The second question we need to ask is, what if AGI? Imagine if these systems really do perform at the level of humans. What does that mean for our traditional way of thinking about how we resolve disputes? And thirdly, I think the question that we might ask is, what is the future of court service? But again, I want to some extent, even challenge that formulation of the question. I think that's the wrong question. I think the question we need to be asking is, how in the future will we solve the problems to which courts are our current best answer? How in the future will we solve the problems to which courts are our current best answer? And my best answer to that, at least today, and at least in part, is artificial intelligence. Thank you very much.
I will be sure to tell Richard that you clapped really loudly. Well, thank you. We're now reaching the end of this foundational session, and maybe I can just try and capture a few things that you could take with you into the coffee break. One again, please go back. Resilient societies, thrive economies, cornerstone. That's why we're here, and we are the system. We are the system. If we don't change it, it ain't going to happen. A couple of things we heard. Deputy Secretary General, you spoke of PCJ, people-centered justice, really being part of something bigger, a trust strategy, which seems very, very needed at the moment, of which open government and integrity are also part. And when you talk about this trust strategy in people-centered justice, it is solving, but also preventing. A teasing question I used to like to ask ministers of justice if I visited them in countries, say, who in your country is the minister for the prevention of justice problems? And there was never an answer, but it did open a mind. State Minister, you gave us a real practical example of how it's done. You need all branches of government. You need to look at more than just the formal system and also look at other ways of solving disputes. And you showed us very practically how important the digital side of it is to actually get things to a solution. A bit like Richard said, stop monetizing the things that are there, but use digital to create different ways, other ways, better ways to get it to people, to improve the lives of people and SMEs. And you showed us how complex, and I think that's something we often miss, organizational change knowledge is. Organizational change is not adopting a law and saying this is reality. It needs a lot more than that. Margaret, you opened our minds with, I think, a complete new universe, thinking ahead 5 years, sharing and working together, which is not inherently easy for lawyers with all their different silos and their complex systems, and engaging with the big tech companies. And largely we had Richard, who, this is a message, even though he knows a lot about tech, he keeps saying, you know, people, service, user-oriented. That's really what should come lie at the heart of what we do. So let's take that to our coffee. I think we have 10 minutes, and then I will reconvene you all. Thank you.
We will now take a short pause for refreshments. Please proceed to the designated area in the foyer outside the auditorium.
A continuación, realizaremos una breve pausa para el café. Les esperamos en la zona de la antesala del auditorio.
Ladies and gentlemen, we kindly ask you to please take your seats as we prepare to commence.
Por favor, solicitamos a todos los asistentes que vayan tomando sus asientos.
Ladies and gentlemen, we kindly ask you to please take your seats as we prepare to commence.
Por favor, solicitamos a todos los asistentes que vayan tomando sus asientos.
Ladies and gentlemen, we kindly ask you to please take your seats as we prepare to commence.
Por favor, solicitamos a todos los asistentes que vayan tomando sus asientos.
Back, everyone. Yes. There, the voice is coming back. Take your coffee inside if you want. But let's get started. Is the panel going to... Okay. Yeah.
Ladies and gentlemen, we kindly ask you to please take your seats as we prepare to commence.
Por favor, solicitamos a todos los asistentes que vayan tomando sus asientos.
Welcome back, everyone. We are going to reconvene. Justice is calling. Well, welcome back. We have our foundation from this session we've had, and we're now going to dive deeper with 4 panels filled with the best experts from different countries, different systems, and different disciplines. In panels of 55 minutes each, and I say the 55 so that the moderators will remember that's what they have, 55. And if they see me standing up, they know that the 55 is nearing its end. They will open our minds and hopefully spur us into action. We'll be looking at AI, data, the economy, and leadership for action. But before we start, just a minute on where we are. The challenging times of today. The Deputy Secretary General said, I don't know what to call it anymore. And I think with that, you echo something we all deeply feel. The World Justice Project Rule of Law Index measures declines in rule of law 8 years in a row, and increasingly in very fundamental parts, most recently the separation of powers. The 2025 World Economic Forum Global Risk report, which I always read, concludes that societal and political polarization is one of the key risks we face in the world today. You all know the ACLED conflict index, which shows that conflict in the world, both between states and within states, is at the highest level for decades, and it doesn't seem to be receding. The Global Peace Index says that the world has become less peaceful for the 12th time in 16 years. You're probably right, Beth, that justice systems are the first and last line of defense that we have against a lot of that. There clearly is a widening gap between the promise of justice and what's actually being delivered. And that erodes trust and fuels instability, undermines economic opportunity, and that brings us to where we are now. And the work we do today, for me, it used to be about people-centered justice. Now somehow it's about a lot more. It's about stability in many countries. It's about economy. It's about real bigger things than just people-centered justice. But, and against that background, we also know that we have a strategy, or at least we have the elements of a strategy, and that's the good news. The OECD recommendation that I mentioned, the amazing data work that is being done by the World Justice Project, by the Open Government Partnership, by Hill and by others, a lot of innovation work that is happening, and trailblazers like you, Margaret, who are opening our minds to what needs to be done if we use AI to help solve the problem. So let's get started with that first panel on AI. AI as an opportunity and as a challenge for justice systems. Can we harness AI to improve access, fairness, transparency, while also ensuring accountability and proper human oversight? We have 5 experts to explore this topic, moderated by Javier Hernandez-Diaz, and I would like to ask you to come to the floor. Javier is the Director General of Promotion and Innovation of Digital Justice at the Ministry of Justice of Spain. And then we have the following members of the panel. Jennifer Saliti, Public Defender at the New Jersey office of the Public Defender. Yes, please. Margaret Lowry, Advisor of the Courts Department of the Ministry of Justice of Estonia. Welcome. Hila Staib, Policy Officer, Digital Transformation of DG Just of the European Commission. And Karim Benkelev, Director of the Cyberspace Laboratory at the University of Montreal in Canada. Javier, over to you.
Hello. Good morning, everybody. I am going to speak in Spanish so I can express myself more freely. And, bueno, pues buenos días. La verdad.
Good morning. This is an exceptional roundtable, and it's an honor for me to chair this roundtable. We have 4 experts, 4 real experts, that will cover different parts of the justice ecosystem, the academic world represented by Karim, government, Estonian government, that will speak about the strategic impulse of AI and other initiatives. We also have with us the Public Attorney Office from the US, and the most regulatory part and cooperation represented by DG Just. I will just do a small introduction of all of them, even though the chair has shown a small introduction in a panel of all of them. In fact, this roundtable will touch on something that is very present, artificial intelligence. What is all about AI, and we're going to speak about transformation of the justice sector, which is something we've been listening to since yesterday and today. So we have a challenge, an interesting channel, to try to get audience attention. We will do a small round of questions, and then we will open a Q&A for the audience. I will introduce the different panelists. Jennifer Saliti, Public Prosecutor in the public office in 2024. Before this position, Jennifer was also Director of Training and Communications for the same office. Previously, she worked as Deputy in Middlesex and also Public Prosecutor Attorney in the Essex County. It calls my attention that she started her career researching on claims on violence in top security prisons. That will give her a unique perspective in the legal world and a very interesting approach to artificial intelligence and transformation. Margaret Laurie, advisor of the courts at the Ministry of Justice, and Digital Affairs, Ministry of Justice and Digital Affairs. This is a clear proof of this European country that is a referent for many areas related to digital transformations. It's specialized in IT systems, legal IT systems since 2005. She's been representative of customers and product owners for judicial IT systems. Thank you, Margaret. Hila Steib, responsible of digital transition policies, judicial information at DigiJust in the European Commission. She's a German lawyer, studied law in Heidelberg and master in Paris, and had a long experience in public and private industries, working for many years as a lawyer at an international law firm in Berlin and in different departments of the Federal Justice Ministry in Germany, digital regulation, civil law, and development of legal policies. She's been working in the European Commission since 2023 as head of DigiJust, working on digital transformation and judicial training. That will give us an interesting point when we speak about digital transformation and training in a sector that sometimes is quite conservative in everything related to adopting new technologies. She's part of the artificial intelligence team at the justice system, and she deals with something very difficult, the link between the law, technology, and fundamental rights. Thank you. And finally, Karim, representative of the academic world, a professor at the law faculty in Montreal University since 1989. He's a member of the Bar Association in Quebec since 1985 and worked at the Digital Justice Ministry of Justice. She's been working since 1990 and a director from 2006 to 2014. He's currently director of the Cyber Justice Laboratory that promotes the access of justice. He has directed a multiplicity of research projects. He's participated in dozens of studies with researchers on the access to justice and the use of artificial intelligence at the legal sector. Just to give some background to this panel discussion, I know we've already listened to the different challenges related to the implementation or use of artificial intelligence, but I'd like to expand it and speak about artificial intelligence and transformation. The OECD reports give us this perspective of AI as a useful tool that has to be focused on the citizens. So we're speaking about transformation that is not only technological, but it's also cultural and organizational. In this regard, I don't know if I have the pointer with me. In this regard, I would just like to give some background on some of the work. Some of the works carried out aligned to the principles of the OECD, the Spanish government, and the Ministry of Justice. Different artificial intelligence services. Someone from the United Kingdom said, we're working on boring artificial intelligence. And yes, it could be boring, but nevertheless it's striking. And artificial intelligence makes you think about those things you want to do. You want to get to breakthroughs and change the way you work, but that's difficult, in fact. When we speak about making summaries, anonymization, translating audio to text during hearing, anonymizing information, those are all tasks we're currently doing. And this is what we're doing in the Spanish government. But we're also doing different things. For example, sperm detection in the tissues analyzed by legal medicine in cases of sexual abuse, to translate a complex legal language into simple or plain language. We're also speaking about transforming rulings in areas related to disabilities in rulings focused on people that might have problems related to understanding, so we use an even clearer language or pictures so that people can access to justice. So even though it's boring artificial intelligence, since we're not using quantum technology or things like that, but I believe it has a very human dimension that makes it closer to the citizens. Some of those examples come from the basis of artificial intelligence, the use of data-driven justice. We will speak about it. The Secretary of State of Justice mentioned a few of them, but this is the basis so that we can apply a responsible, secure, and accurate artificial intelligence. In this regard, using automation in artificial intelligence, process automation, or data themselves, that will give us a possibility to analyze our judicial systems, but using this data to improve our citizens' lives and reduce the impact of social conflicts in a country. So this is what is artificial intelligence being data-driven. I believe we all share that is part of a broader initiative, which is the time of a cultural change and social transformation of the justice sector. So this type of forum, and congratulations to the OECD and some others in other countries, as the ones you can see here from the Spanish government, allow us this co-governance, cooperation, learn from each other, and a cultural change for our users. So this is the background, the guiding principles that OECD tries to promote thanks to the wonderful reports they make, and we're going to give the floor to the real protagonist of this panel discussion. We're going to start by Hila. The regulatory work at the European Commission, we all know it, is fantastic. I believe the regulatory power of the European Union in this field is fantastic, and also what you're doing in the area of international cooperation. I'd like to know what is the impact of this regulatory work at the justice sector in Europe, and what are the cooperation initiatives that could be relevant for this audience?
So, thank you very much. Well, so to answer your first question, what impact does the AI Act have on the justice systems? Well, we think it will have quite an impact, and it does have quite an impact, because with the AI Act, we really try to encourage the uptake of AI also in the justice sector. But the impact will also depend very much on what kind of AI tool or AI system, as it's called in the AI Act, is being used. So I'm just, yeah. So in the AI Act, we have a risk-based approach. And most systems will probably bear minimal or even no risks and to citizens' rights and safety. And for this, under the AI Act, those systems face only few or even no obligations. And we think this will be true for probably quite a majority of AI tools that are used in justice, at least so far. But there are other systems that will bear more risks. And those are classified as high risk in the AI Act. And according to the AI Act, those systems must comply with quite a number of specific requirements. I just name a few because it's really quite a number. For example, a risk management system must be established. There are transparency and cybersecurity obligations, and deployers must perform a fundamental rights assessment. So it really makes a big difference if an AI system is classified as high risk or not. Now, for the area called administration of justice in the AI Act, we have a definition under Annex 3 of the AI Act for high-risk systems. And those systems are intended to be used by a judicial authority or on its behalf in researching and interpreting fact and the law, and in applying the law to a concrete set of facts, or to be used in a similar way in alternative dispute resolution. And then at the same time, we have a carve back in the AI Act saying that in any case, AI systems that are intended to fulfill purely ancillary administrative activities that do not affect the actual administration of justice in individual cases should not be considered high-risk AI systems. This is laid out in more detail in the AI Act, but I just summarized this roughly. But what it shows, maybe you can also see this on a slide, it's not quite obvious at the first glance what will be a high-risk system and what is not. There might be some cases that are clear, for example, tools that are designed to draft a complete judicial decision based on the content of the file. That will probably be a high-risk system because that really applies the law to a concrete set of facts. But other systems that are only used, for example, to anonymize judicial decisions will not fall under the high-risk category because this would be considered a purely ancillary activity. But especially for the cases that are not so clear as the two that I just named, we are now developing guidelines to make clear what is meant by those provisions exactly. And we have had intense discussions with the member states on this. We're now finalizing those guidelines, and we're planning to publish them at the beginning of next year. But in any case, it is really important that no matter if a tool is high risk or not, they can only be used to support judges in their decision making. So they can never replace this. And the final decision will always be a human-driven activity. And of course, the AI Act only constitutes a legal framework focusing a lot on this differentiation between high-risk and low-risk AI, but it does not take away from the member states the decision whether they should use an AI tool and for which purpose. So as we already heard also this morning, there's much more when it comes to AI and justice, and therefore I would like to explain a bit more on other important initiatives we have. So for several years, member states have been discussing the use of AI in the e-Justice Council Working Party. So they have exchanged information on their national digitalization initiatives, and they have also collected information on existing digital tools and how they're being used. And based on those discussions, in December 2024, the Council finally approved a set of Council conclusions on the use of AI. And these conclusions highlight, of course, the risks, but also the opportunities of using AI in justice. The Council stressed that AI must enhance efficiency and access to justice, but at the same time, of course, fundamental rights and other applicable laws, such as the AI Act and data protection law, must be respected. The conclusions also call on the European Commission to create a justice AI toolbox and support research, cooperation, and training. And finally, member states are really encouraged to adopt AI and also to share the best practice and invest in digital infrastructure and judicial capacity building. Now, the goal of the European Commission is to support the member states in this, and this brings me to a very important initiative, which is the Digital Justice Strategy. The aim of this strategy is to really speed up the digitalization of justice systems across the EU and to make them more efficient and accessible. And this strategy will actually be published and adopted next week, so the 20th of November. And the strategy is very comprehensive. I just want to mention two parts that are focusing on AI and justice. One part is the creation of an IT toolbox for justice. We already heard a little bit more about this morning, how important it is to use collaborative work and to share best practices, and that's really the idea behind this toolbox. This has already been proposed in the Council conclusions that I just mentioned, and with this toolbox, we try to encourage member states to share their tools with each other, because we know there are quite a few member states that have quite interesting tools. We already heard about this morning also. And this helps, of course, saving costs and time for everyone. So member states can decide if they want to share a tool with others and to what extent, of course. But we really hope that it will speed up the process a lot. And then the strategy also contains a very important part on the use of AI in justice itself. The Commission will identify together with the member states specific areas where the EU can support them in the uptake of AI. We don't know exactly what this will look like in the end, but there could be some alignment, for example, on questions like if AI could be used in a specific sector, for what purpose it could be used, and how it could be used. And finally, I would like to mention the Commission's new judicial training strategy, because if we want to enable justice professionals to really benefit from digitalization and use it responsibly at the same time, we need to focus on strengthening their digital skills. And this is why the digital justice strategy is going to be adopted together with the judicial training strategy. And this strategy focuses really a lot on digitalization. It aims to develop digital skills, but also to build knowledge on substantive law in the context of the digital economy. So with all those strategies, we hope to make the justice sector fit for the huge transformation process that it's facing right now. Thank you.
Thank you, Ezequiela. La verdad es que es muy importante esto que has dicho y estoy esperando.
Certainly what you said is very relevant, and I can't wait to see those documents, particularly this toolbox you spoke of, but also those training opportunities, which are much welcome in these times. So over to you, Jennifer. As we said, Jennifer works as an ombudsman, which is a fundamental function to protect the rights of those who are most vulnerable or have fewest resources to access legal support. So what AI initiatives are you applying in this particular line of work where you work with such specific matters? Do you have any examples you would like to share with us? Thank you if you do.
But really the fundamental question that we have asked ourselves in my office is, what if AI could make us more human, right? What if we can use AI to allow our lawyers to really focus on client service, which is at the core of our work? What if it could free our lawyers from the mundane, right? Free our lawyers from high time tasks that require a lot of time and allow them to think more deeply and creatively about their cases. So those are the questions that I sort of asked myself when I took over the Office of the Public Defender in 2024, and things that we have been moving forward with. I do want to start by giving you a little overview of my organization, because I think it's unique, and I think there is some misconception, and we have a lot of people here from a lot of different countries. So what the public defender's offices do in various states is represent people who cannot afford to hire attorneys in court. The New Jersey Office of the Public Defender is a statewide system. We have 3,200 employees, 750 lawyers, 66 offices, and 21 regions. We are the largest criminal defense attorney in the state. We are not prosecutors. We do not prosecute cases. We defend people in court. In addition to representing people charged with serious crimes, we also represent parents and children in neglect proceedings, and we represent people who are mentally ill and in danger of being civilly committed to mental health facilities by the government. So what our lawyers are doing every day is standing next to vulnerable people in court and protecting them from the state, protecting them from prosecution by the state. And I was appointed to my position by the governor of our state in 2024. And when I started thinking about what Richard this morning called the hole in the wall, I love that analogy, right, of the hole in the wall. The hole in our wall was high caseloads. Our lawyers have a lot of cases, and it is very difficult for them to often manage all the tasks they need to do associated with those cases. So as we've looked at that, we looked at ways that we could use AI to improve a number of processes within our agency, but specifically doing three things. One, to build our own internal tools that can help us reduce the time it takes our attorneys to do certain tasks. Two is by participating in working groups with the judiciary and other members of the legal community to make sure that AI standards both advance the technology and protect vulnerable people in court. And three is by leveraging our existing state government AI tools. So I want to start by talking about the first one, which is our AI brief bank. The state of New Jersey has this very interesting organization called the Office of Innovation. And as I think many people in this room know, government works slowly. So New Jersey created this Office of Innovation in order to sort of bridge that gap between governmental processes and technology and the fast pace of technology. And the woman who headed that at the time I met her was Beth Novak, who I'm sure I see lots of smiles and nods. That's how I got here. Thank you, Beth. And I met her, and this morning, I think Margaret said something about technology happening to you. The first thing I said to Beth was, I do not want AI to happen to me. I want to lead. And I want to not just use it to lead our office, I want to use it to get a jump on even private law firms. I want to have better AI than the private law firms in New Jersey do. So we conceived of a project. She asked me, she didn't use the words hole in the wall, but she asked me about my hole in the wall, and my hole in the wall is brief writing. It takes a really long time for lawyers to cobble together legal briefs from other briefs that other people have written, and they cut and paste, and then they go and they do legal research. So what we have developed in conjunction with the Office of Innovation and Princeton University is a legal brief bank that is controlled by us, built by Princeton for us. And it allows a lawyer to type in a legal question in their case, and this AI will create the brief. Lawyers, of course, have to check it, but it allows the lawyer to, in seconds, do something that used to take them days, so that then they can focus on working with that client to customize the brief, to personalize it, to really, really make these briefs sing, make them very, very creative in court. So that's one of the technologies that we're very excited about, and we've been working to get that up and running. Another thing that I think is really interesting and worth pointing out about public defenders and AI is the space in which we sit. Right? We want to use AI to the benefit of our clients, to the benefit of our lawyers, but we also have to be in court and protect our clients against AI tools that don't meet the foundational reliability for it being admissible in court. So when I look at it, and I mean, it's not a secret to say that one of the big problems, at least that we see in the United States, is the way implicit bias can creep into AI systems. I don't think it's controversial to say that at least the American legal system has had a history with implicit bias and institutional racism. And so we are looking to make sure that any AI tools that are developed, we are looking out for things like flawed algorithms, for racial biases in embedded historical data, and for feedback loops that reinforce discriminatory practices. We're seeing a lot in predictive policing. So where AI can disproportionately target minority neighborhoods, leading to over-policing and higher reported crime rates that further fuel systemic inequities. So our lawyers have to be prepared to fight against that technology in court. Also, when it comes to forensics, we're seeing a lot of forensic technology is a black box. We don't know how it works. And now we're adding AI into forensics, so in DNA, in fingerprinting, in ballistics, coming into court. So we have to train our lawyers also to be a bulwark against ill-conceived technology coming into courtrooms before it's ready. But I guess in summary, what I want to say is that despite all these challenges, that AI can really be a powerful tool for social justice if it's deployed responsibly. So one of the other things we are really doing is teaching our lawyers to love it, to embrace it, to not be afraid of it, to not let it happen to them, to make sure that we are a force for ensuring that when AI is used throughout the justice system, that it is being used to the benefits of the often marginalized populations that we serve. So when I go back to my initial question about using technology to make us more human, it can enhance our work, but it's humanity that drives justice. And when AI gives us the time to think, to listen, to be creative, and to care about the people we serve, that's how we fulfill the promise of public defense, which is putting people at the center of everything that we do.
Pues muchísimas gracias, Jennifer. La verdad es que es...
Thank you very much for that explanation. It's very interesting to see how you're working to prevent systemic inequalities, right, that are sometimes linked to those unknown workings within the AI, however, providing a very positive balance to bring a human component into the work. Over to Karim then. Karim, you run the Cyber Justice Lab of the Montreal University. I did a little bit of research myself, and I must say that you do a wonderful job. Congratulations. According to your own description, yours is a center for creativity where legal processes are reinvented. Wow, that's a big statement. What can you tell us about the experiences of this center with AI tools? Do you have any specific methodology? Have you detected positive impacts? Tell us about it, Karim. Thank you very much, Javier.
Mainly in my short presentation about methodology, which I think is at the key of the topic. In fact, at the Cyber Justice Lab, we don't like the expression artificial intelligence. We prefer augmented intelligence. The goal is to augment the capacity of the citizen. And we've developed tools specially for the citizen. I will come back to that later. There is a common belief that technology is neutral. Of course, it's not true. The design of a bridge will determine who can cross, and today, as we integrate AI into our justice system, we must also recognize that its design will also determine who will get justice. So we have witnessed in the last 20 years, 25 years, the consequences of introducing technology without adequate oversight. This means we must consider the societal changes that technology can bring right from the design stage. So we are not simply automating old processes, we are building a new data-driven interface between citizens and the state. And the main question we then must constantly ask ourselves is, how do we govern it? How will this technology shape power, due process, and the fundamental relationship between people and our judicial institution? I believe that the primary barrier to creating a just AI-powered legal system is not technological, but institutional. Based on the work being done at the Cyber Justice Lab, I will present very shortly a framework for turning people-centered principle into practice. We need a new model. At the Cyber Justice Lab, we've developed a framework for responsible innovation built on 3 pillars: co-design, accountability by design, and the living lab environment. Co-design. Effective judicial technology cannot be engineered by technologists alone. It must emerge from the joint efforts of legal experts, social scientists, and the citizen, civil society, which it's meant to serve. So we design with users, not for them. Our Technology Through Cyber Justice Technologies project put this into practice by integrating judges, lawyers, and end users into the design process from day one. We make sure the tools we build solve real-world problems and are trusted by the communities that use them. Accountability by design. Instead of pursuing algorithmic complexity, we pursue accountability. Our tools must be explainable, auditable, and aligned with due process. JusticeBot, a tool that we've developed, a chatbot that we've developed at the lab, is a good example of this approach. Unlike predictive tools that tell you whether you will win or lose, JusticeBot is designed to augment end users, not replace their judgment. It guides a user through their legal problem, for example, a landlord-tenant dispute, and provides relevant legal information and similar past cases. It helps people to make their own informed decision. Our LL Mediator project also demonstrates this approach. The AI can suggest more neutral language for an angry message or draft a response for a human mediator to review and approve. But very importantly, the human always have the final cut. Third, Living Lab. Both co-design and accountability are put into operation in our Living Lab, a safe, controlled sandbox where courts, practitioners, and researchers collaboratively prototype, test, and audit new technology without risking real-world rights. So instead of designing in isolation, we co-create in a transparent environment with governance, data stewardship, and ethical review baked in. The Living Lab allows us to validate assumptions with real users, measures impact, and install safeguards before scaling. So we co-design the right problems, we build accountability into the solution, and we prove both in a living lab before deployment. So how do we scale this model? For justice leaders in the room, I offer 3 strategic recommendations. First, create, and we spoke about it earlier, create justice innovation groups. Foster interdisciplinary centers like the Cyber Justice Lab to break down silos between academia, government, and industry. Not just jurists or technologists, psychologists, historians, philosophers must be involved in the project. Second, invest in bilingual talent, not French and English or French and Spanish, no. Bilingual, we need professionals fluent in both legal reasoning and computational logic. Algorithmic literacy must become a core competency for the next generation of lawyers and judges. Thirdly, build a tech-ready judiciary. Courts must modernize their digital infrastructure to create a foundation upon which new responsible technology can be built. A lot of our courts are still based on paper. So before talking about AI, we must maybe try to modernize the court. Last but not least, set up public interest data trust. Govern justice data for public good, research and accountability, rather than for narrow commercial extraction, under independent oversight with clear access, audit, and redress mechanism. And finally, in closing, the path from principle to practice is not a technical roadmap. It is a commitment to a human-centered methodology. A judicial system worthy of public trust will not be determined by the sophistication of its algorithm, but by the values we choose to embed in its design. It will be built through collaboration, validated in a real-world context, and held to the highest standard of transparency and accountability. The future of justice is not something we will discover in a data set. It is something we must design together, deliberately and responsibly, to uphold the values we hold most dear: fairness, transparency, and of course, equal access for all. Thank you very much.
Muchísimas gracias.
And thank you very much, Karim. You may have noticed that ultimately, in the face of any transformation, the sole way ahead to transition involves co-creation, cross-functional teams, cooperation, and the deeper the gap, the more relevant it becomes to apply some of the concepts Karim was mentioning. And it is so difficult for most of us when these AI processes come from sources that are unknown to most of us, like that black box you mentioned. Well, I can't wait to see lawyers programming in Python. I don't know many who actually can, but I believe that, I don't know, the legal professional of the future. So last but not least, we look to Estonia, Ministry of Justice and Digital Matters. It sounds like odd partners, and yet it's part of your DNA based on the very name of your division, right? So I can't wait to hear the initiatives your government is fostering in terms of AI, particularly one aspect, change management. How are you dealing with that?
The name is not an accident, it's deliberate. I represent a small country where all funds are limited. Human resource is very limited, so we have to work very efficiently and always look for innovative ideas. So when we had a new government, the first idea was to combine Ministry of Justice and Digital Affairs. Again, it didn't come out of nothing. The digital affairs people were complaining that all the regulations and laws are obstacles to innovation, and the justice sector and the Minister of Justice were complaining that they can't do anything without it being connected to an IT tool or AI tool. So it seemed logical And I think the joining of the forces has been successful. Both sides have gained a lot. Just an example, in the justice sector, we use and develop a lot of chatbots that are meant to help regular citizens who, for example, want to submit a claim to a court. So again, there are a lot of products in the market to choose from, but the quality standards in the justice sector are quite high and the funds are limited. So again, this needs a lot of expertise from the digital side of the government, which one to choose, which one is safe, how to train it, who you can partner up to develop the system. So nowadays we have multiple chatbots in use already and in works, and we actually see that, again, as the funds that are allocated to legal aid are quite limited and the expenses go up, and we have to find new solutions. So we thought that, okay, we'll have a chatbot that's trained on the most quality data that the courts and the government has. And it will replace some of the need for legal aid. And it's easy to use, easy to have very, very good results. And the first tests that we have done show that it's actually, for us, it's the future of legal aid. Of course, there are people still need in-person guidance, but in general, the first step you take, not go to see a lawyer, but to have a chatbot that will answer you, will give you an answer or what you should do. And I think the biggest transition in the judiciary, a couple of years ago, we went from paper to digital, and then we realized, okay, now we just have a lot of files. Okay, let's now put all the AI tools we have to work with the files. Kind of seems like we're putting out the fire that's still burning. So what we realized that we actually need data-based proceedings. And if you look at it from the court side, you cannot start from the courts. You have to start from the citizen who submits a claim to a court and how the police and the prosecutors are collecting data. So again, a lot of cooperation between different ministries and different sectors of the judiciary. But yeah, now we have come to a realization that the citizen or the lawyer who wants to submit a claim to a court has to submit data, not files, which allows, again, for the AI tools already be used before the case arrives in the court, so that there are a lot of data that the government already has. For example, alimony cases. You start to present your data, and there already the system can tell you that where that person works, what's the salary. You can ask different data from different government registries. So when the case gets to the court, most of the work already has been done behind the scenes, and the court has all the relevant data, and the person will get to the end results much quicker. So this is something that we're currently working on.
Pues muchísimas gracias, la verdad es.
Outstanding. Thank you very much. Actually, it's encouraging to see that other places around the world are working on similar things with such a positive spirit. I was just thinking about how the use of technology has evolved concerning not just legal systems, but governments in general, the public sector. I remember that when we were exclusively data-oriented, we had to deal with data quality. Then when we started using bots, we went from normalcy treatment to exception treatment. When the agent gets it wrong, when when the technology makes a mistake. But now we take a further leap. It's not just about data quality and exception quality. We now have to deal with inaccuracy, right? The lack of accuracy in systems. So we're facing an increasingly complex system that will require plenty of professionals, engineers and legal professionals that will apply checks and balances to data. So before we go into the Q&A session, I would like to ask all of you a single question, 1 minute each to answer. Where is Justice AI in 5 years, 5 years from now?
Two things. There's a lot of people here that are a lot smarter than me that will tell you what the future of AI is. But I think about it in terms of someone leading a government organization, is that I think a fundamental shift we are going to see is that the technology staff is no longer going to be separated from the legal staff. At least in New Jersey, one of the things that we are doing is totally restructuring our technology department to partner with lawyers to be cross-functional so that it's embedded into the legal part of the work. It's no longer separate. Doing everything from identifying secretaries and paralegals who have technology expertise and then moving them to the tech side so that they can serve as liaisons with the lawyers. I also think that by shifting the organization this way and doing everything, trying to use AI everywhere we can, then that gets us faster. It builds capacity faster, right? When we think about the ecosystem and capacity building, that allows us, without hiring new staff, to build capacity. And that will prepare us to get to the next phase, which I think really is the future, is to interacting with clients with AI to augment the relationships we have with them, to have processes where our clients can communicate with us through a lot of AI tools, and that way the time that the lawyer is spending face-to-face with the client can be maximized.
Muchas gracias. ¿Tú, Martit?
Just looking at how fast the developments have been in the last 3 years, I think in the next 5 years, AI is the norm, and hopefully with that, it means that it's not that expensive anymore, because at the moment developing and housing an AI system is quite expensive. So hopefully, as it will be the norm, and there will be a lot of options on the market, and the experience of how to develop and house the systems will be much higher, then I think it's much more affordable. And yeah, I think in 5 years, quantum computing maybe will replace some part of it. But yeah, I think it will be the norm.
Thank you. Hila?
Well, I basically hope that all the ideas and strategies that we're working on and that are just coming out right now, that they will turn into reality and that we see the results, which means that we would have just a sector that really confidently uses AI tools and is very efficient, of course, that we have member states sharing tools and saving a lot of time and money for everyone and share their experience. And of course that we have justice professionals also that are trained very well and they have great digital skills.
Yes, well, I'll see AI in justice for the citizen. So my prediction or my dream would be that in 5 years, each citizen in Quebec, in Canada, could solve their low-intensity dispute, consumer dispute, tenant, landlord relation, credit, stuff like that, not with the artificial intelligence, augmented intelligence judge, but with the tools to facilitate negotiation, mediation, and of course the resolution of the conflict by suggesting some possibilities, some outcomes that could be beneficial to the citizen. So that's, I think, what AI could do best for the citizen in 5 years, hopefully.
I love those positive messages for everyone of you. Me encanta que seamos tan positivos.
I love to hear all these positive outlooks on the future. Perhaps before we go into the final remarks, we could hear some questions, if we have any. Questions for any of the speakers?
Then? No? Yes. Here. No, oh no, okay. Okay. Bueno, pues,
well, in that case, and since we have a tiny little bit of spare time, I would personally like to make a 5-year forecast. I recently attended an event and I was talking to Jose Ignacio Latorre. He's a quantum physicist working for the Singapore government. And along with Kat Martadel, he was the director of the Barcelona Supercomputing Center. And we were talking about geopolitics, the geopolitics of AI. And he was telling me that China has this clear target of becoming #1 in technology and AI. And in that event, I heard that 80% of Chinese ministers are engineers, whereas 80% of ministers in European countries are lawyers. Can you notice the change in perception? It's such a different approach. AI applied to social media in China tends to standardize the society, whereas in Europe, it tends to create small pockets of feedback. So when I try to extrapolate these thoughts to justice and AI, I would venture say that justice-applied AI systems will be super specific or will not exist at all, unless general AI comes in and we take truly a quantum leap in the implementation of AI. I would say the sole way to remain useful in an industry or a sector like justice is working with multidisciplinary teams applied to online discrete resolutions.
Make more efficient the governments, pero creo que, sinceramente, creo que debemos trabajar en creación de sistemas expertos específicos antes que buscar la grandiosidad.
But I would say, rather than a grandiose quantum leap, we will be seeing hundreds or thousands of new AI systems that will be applied to a myriad of cases or uses. So thank you so much for your time and for coming over to Madrid. I hope you're enjoying your stay. Let's hear it for our speakers, please.
Thank you very much, Javier, Hila. Get all the names. Margit, Karim, and Jennifer. All right, we now turn to data, ladies and gentlemen. I will not try to summarize what was said. A couple of things do stick. One is the European Commission making it clear that it must be regulated well. A second thing we heard is the importance of the human dimension and using AI to strengthen the human dimension. Thirdly, I really like what Karim said, to build in co-design, accountability, and learning in whatever you do. And Margaret really emphasizes the need to integrate the different elements of government together. We're now going to turn to data. How can it be harnessed effectively for improvement of justice systems? If we have better data, Then we know what users need, and we know what they get. And that'll help us make better strategies and policies. This panel has 4 leading experts on data and will be moderated by Aitor. Now, Aitor, I don't know what you, Aitor, sorry, very sorry about that. What would you prefer, that you introduce the panel members or that I do? Yeah? Because otherwise then we don't have it done 2 times. So we have Nicholas Goodwin. I will not repeat what he does. It is on the screen here. Esther Bogart from the Australian government and Adrian Franco Barrios. And if I'm not mistaken, we will have Justice Aidan Chu of Singapore speaking through a pre-recorded video message later. I will hand it over to you, Aitor.
Thank you very much. Good morning, everyone. I will start the panel in English, but the introduction will be in Spanish in order if you want to use the headset. This is a quite important panel about data-driven justice system. And we will share with wonderful speakers for all over the world, because it's a key topic that is quite common in all the panels, but it's important to know about what is data-driven justice. Buenos días a todos, buenos días a todas.
Good morning to everyone, and welcome to Madrid, to this wonderful event co-hosted by the OECD and the Ministry of the Presidency, Justice and Parliamentary Relations. In this panel, we will see how different countries are making transitions towards justice ecosystems, data-driven justice ecosystems to improve citizens' lives and also businesses' lives. And we need to focus on this in a realistic manner, and we need to do it always. We're moving from a model where justice was driven to paper and documents to a digital justice system that now moves into a data-driven justice system. And the strategies we need to reinforce governance, to improve interoperability in complex countries with federal structures, in a complex world in Europe, where we have more and more international organizations and exchanges of information, with a clear risk management and measuring and evaluating the needs and the situation. How can we combine those? But let's go to the practical domain. As it was said at the beginning by the OECD, we need to move from theory into implementation. What do we refer to when we speak about data-driven justice systems? Let's say I need to share my data with my colleague Marianne at the OECD. How would we do it in a traditional world? I will give her my business card. Of course, this has limitations, important limitations. I need to be close to Marianne in order to give her my card and she gives me her card. But we need to be close. When we move into a digital justice system in an environment where digitalization is present at the different information systems, I can send her a picture of a digital card or a picture with or an email with my contact information. This is digital. And this is a situation where many countries are at now. What have we done in Spain in the last 5 years? She have a data-driven justice system. It's not giving her a card. I share my contact by WhatsApp, so I can share my data, and I know it's accurate data. Marianne will not make mistakes when typing my name, which might be difficult, or when typing a phone number. She is going to save a great deal of time and avoid mistakes in an automated and immediate manner. But let's imagine it's not only an exchange of contact information, but the administrative file of a tax process with 80,000 documents in a criminal case at the national court. That's being data-driven. To be able to exchange information and not documents, information among systems in order to have automated actions and apply artificial intelligence is really a paradigm change and is quite significant. To that aim, we're going to speak during this panel discussion about how can we collect, use, and exchange among different institutions, because the justice system relates to hospitals for forensic reports, with law enforcement to exchange information, with victims' attention centers, with penitentiary institutions. So we do not only have to think, as it was said by Strong for presentation, we don't always have to think about our field. This is a wider field, a larger ecosystem. And something that is also important is very often the case to have enthusiasm for technological projects, the state of the art in artificial intelligence, or what is sold by a certain company related to certain projects. But this does not change a country. We need to try to get a structural change, as the Secretary of State said, deep reforms that will impact different levels at the same time. It's important to have digital justice, and digital justice should reach all corners, all municipalities, from the smallest to the largest, to all jurisdictions, including criminal one, and to all the courts, from the first instance to the Supreme Courts of the countries. They should all be digital. If our judges cannot sign electronically, we can play with different artificial intelligence projects, but we will not be really changing the way the country is operating or functioning. With digital justice, we can make the step towards database case management, to exploiting information and decision-making of public policies data-driven. But we need a digital ecosystem embedded in this functioning, and this change to being data-driven, as the Secretary of State said, needs a legal backing and tools that will allow, with soft law, a certain coordination. The data manifest, the Spanish data manifest, is translated in English, is also in Spanish, can guide us in this change. But I insist, transformation is larger than a digital project. And just an illustration, as was introduced also by the Secretary of State, the case management is automated. 80% of the employees may no longer be necessary. You need a framework to allow those employees to do something different. Otherwise, they will be stoppers of the change. They will feel they will lose their jobs. So we need to think about the projects, including the wider picture. If we don't see the complexity of the system, the implementation of certain technological solutions could end up not happening due to certain blockers or stoppers. And technological solutions improve people's lives. The illustration by the Secretary of State. Economic movements in the justice system in Spain at the ministry, they are carried out by robots. The robots work every night. In the past, you had to wait for a civil servant to read a document, to check if there was money in a bank account, made a payment to a third party. You rely on someone that could be on holidays or maybe busy with criminal cases, gender violence cases. Now is the robots doing the job every night. You could be waiting for a payment for 2 months, may not seem to be a lot in our industry, but if you need the money to buy your children's food or to pay the rent or to cover a need between businesses, so one of them could go bankrupt, then 2 months becomes very long, and those robots work every night, and that's being data-driven. We can only do it in this way. If you need to read the whole document, you cannot do it. If you need to process data, robots can do it, and then people's lives is finally improved.
Because we want to know how to improve the life of the citizen and our companies, and we will start with the different speakers that are right now here, but we will start first with a video intervention. The message will come from Aidan Xu, that is a judge for the High Court in Singapore.
Good day, everyone. It is indeed a great honor to have been invited to speak at this session on the Singapore experience in building institutional capacity for data-driven justice. In these 3 minutes, let me give a broad survey of what we do in Singapore. In common with many judiciaries, Singapore faces multiple challenges ranging from increased complexity and volume of work to greater expectations from court users. Developing the proper response requires accurate, current, and relevant information. In Singapore, we previously implemented the Justice Scorecard, essentially a periodic report capturing various factors governing court performance. However, we have, for a number of years, moved away from this scorecard modality, which was static, and have instead focused on the development of Tableau and dashboard systems to capture dynamic, close to real-time data. But the factors covered by the Justice Scorecard remain relevant and have been incorporated in our reports. The 3 courts making up the Singapore judiciary, the Supreme Court, the state courts, and the Family Justice Courts, each have a dedicated statistics and analytics unit, including the Data Analytics and Research Department of the state courts. We benefit from an extensive extraction of data from the different electronic filing and case management systems used throughout the judiciary, though we intend to improve this in the development of our unified future case management system. Efforts are also continuing with the development of a dynamic dashboard for our Chief Justice, capturing relevant and salient data while giving as an accurate and fair picture as possible. While technology is important, technology cannot deliver results on its own. We need an organizational culture focused on accuracy, timeliness, and service centricity. This requires sustained inculcation of values and training. In addition, there has to be strong leadership, with the leader setting an example for the rest of the organization, emphasizing to the judges especially the importance of such data collection and interpretation. Without such commitment, all the technology and systems in the world will come to naught. Finally, it must be seen that the data is actually used in the organization's decision-making and initiatives. A perception that data is collected only for collection's sake will only breed cynicism, disengagement, and gamesmanship. An example in Singapore of this combined effort in responding to a clear challenge is our effort to facilitate access to justice through the development of Gen AI assistance for self-represented persons as they pursue small claims. Only by having this holistic attitude towards collection, interpretation, and action from data can we ensure that the justice system serves the people. Thank you.
Thank you, Aidan from Singapore. We will start the panel here in Madrid. And first, we will talk with Nicholas Goodwin. He's the Chief Executive of His Majesty's Court and Tribunal Services, who will share his experience leading a major digital reform program that transforms how courts works and progress in the United Kingdom. Nick, the floor is yours.
Well, thank you very much for inviting me along today. As you said, I am the Chief Exec of the Courts and Tribunals in the UK, and when I spoke yesterday, I reflected that we've just been through a massive change. So an 8-year change programme that digitalised every single jurisdiction in England and Wales, to the extent whereby all our courts can run completely virtually if needed. And yet, having reached that stage of maturity, my overriding feeling is that we must do a lot better. We've got a lot more to do beyond just getting rid of all paper and all email. And my reflection is based on a few things. Firstly, better data opens our eyes to more opportunities than we ever knew before. The second reason we need to do better is users are demanding that we do better. Last year they were happy with a service that's better this year, and now they're less happy. So we have to go with the changing world. Also, cases are becoming more complex, there's more evidence, there's more data within them, and demand is rising. I said yesterday that it's entirely possible for someone sitting on a bus with a smartphone and an AI lawyer to litigate a case from start to finish in our system. That's great, but it's also quite scary if everyone on the bus is doing exactly that. The third reflection about why we need to improve and focus on a user is that as we have implemented our changes, we've learned a lot more from our failures than our successes. And so every day we see there are new things to be fixed, and no matter how much time we put into designing systems perfectly or planning for implementation, we will fail, and therefore we need to improve, okay? So to deal with this, there are three things, I think. This is the first one, which is about data, the foundation of improving services. In the UK, we have, well, data and insight is more important than ever. So every single decision requires data. We can't make a good decision really without good evidence. We understand that. If we want to get our resources in the right place, we have to look at the data. We have 4.5 million cases going through the UK courts each year. Each case has hundreds of different data points. We therefore have billions of different data points if we look at the UK system. And that wasn't there before, and it was in different systems, and now we have it on one bespoke system. But all of that is completely meaningless unless you know what you're looking for. So the most important thing is this: you must have a data strategy to understand what it is that you want to collect and how you're going to use it and how you're going to communicate with people about how you're using it and how you will then be transparent about it. The second thing I would say in respect of data is dangerous, right? There's no two ways about it. It's obvious if you put poor data into systems, you're going to get the wrong output. The other thing that is really clear in digital justice systems is you cannot design out error entirely. And therefore, any user error will come through your data, and if your data is wrong, you'll make the wrong decision. Similarly, with digital justice systems, digital case management systems, if they are not accurate, you're in big trouble. And therefore, it's really important to make sure data quality is excellent and make sure your systems are fully auditable, because without that, you lose all trust in this magnificent infrastructure that you've created. As a CEO, I'm not a data expert, right? But data is the root of all my happiness and sorrow, right? On a good day, I will wake up and someone will say, data is telling you something good, or data is telling you something really bad. That's brilliant, right? A bad day is when you look at the data and it's wrong, right? It's a crisis. The second thing I think I want to talk about, the next slide, is about user experience. So data, in the way that I've spoken about it so far, is about pulling stuff off case management systems. But we need to directly respond to user experience. It's that tells us how well users are experiencing our services, how well we are meeting access to justice. So concepts like fairness, confidence, trust and motivation don't come through case management data. You've actually got to talk to people in some sort of way. So you need to collect data, as this says, systematically from the start of the case, through every part of the case, and then after the case. And that is incredibly difficult to do, but incredibly valuable. So we're piloting new ways of collecting data and looking at different parts of the journey, as well as looking at how performance data can be used as a proxy. So if you want more information on that, Luke Ullman is in the room here, absolute expert on it, and he's been working with the Netherlands as well to see how you can benchmark how good you are at collecting user insight. For me, the big thing with user insight is it helps us to improve our services. That's good for the public, but if I'm running a service, that's even better for me. If I'm getting rid of failure demand, I am focusing all my resources on solving a problem, not complexity. The third thing I just want to highlight was on AI. You just had a session on that, so I won't go into it too much. But from our perspective, AI is about simplifying the complex. Very often, that's what we're trying to do. And you'll have seen and talked about frameworks before, but our framework is based on appropriate, safe, and controlled use, and absolute transparency in terms of how we are using AI. There's a list of things up here. This is a short list. We have a list of hundreds of things we can do through AI, but there are a few things I really want to land with you. Most AI is very boring, right? We are using boring but powerful AI, and I think that is something to bear in mind. We also look to solve real problems, okay? We're really focused on the pragmatics of using AI. Don't dream up a magical new future, but be very practical in your approach to AI. And then the last thing is, we're really, really careful about a process which is about scanning, piloting, and then scaling, and doing it incredibly carefully. There are some brilliant things we can do, but we will take our time and get it right. So there's some very boring things, right? Making sure staff understand their jobs, and then some more exciting things. But everything has to have a very structured approach. One last thing, if I may. Beyond all of this, the most important thing we have learned in terms of meeting user need is you need a golden thread throughout your organization. So from myself to Luke, who does the research, to the teams that change the digital systems, to the people that are face-to-face with the customers, to the customers themselves, you all have to have exactly the same understanding of how things are going to be approached as far as possible. Because when that departs and you get gaps, you create huge problems and huge error. And so the more integrated you can be, the better.
Thank you. Thank you very much, Nick. Yes, got almost an applause. I want to highlight, just after your intervention, the quite important user experience measurement in the project. Is quite important to know how the project goes with the citizen and also with the user that are inside the justice system. And the pragmatic and boring AI, but they have to solve real problems. Maybe it's not fireworks, but it works, and that's nice. We'll continue our panel right now with Esther Bougard, First Assistant Secretary, First Nation and Justice Policy Division from the Attorney General's Department. And she will speak about how Australia has been using data to enhance service design and delivery. The floor is yours.
Thank you. Good morning, everyone. So Australia, I would suggest, is slightly behind the UK, but we are very much recognising the collection and the harnessing of high-quality data being critical to improving justice outcomes in Australia. When used ethically and responsibly, data is a powerful tool, and it can help us to identify unmet legal need, eradicate bias and discrimination in our systems, and design more effective interventions that work better for people and communities. I thought I might start where AI has been a common theme throughout, so I was just going to talk a little bit about some of the foundational work that we are doing around AI and data so that we can build our justice systems upon it. So two things I'll just mention quickly, and I may have mentioned, I did mention yesterday that Australia has developed, the Australian Government Digital Transformation Agency has developed a policy for the responsible use of AI in government, which came into effect in September last year, and it aims to ensure government plays a leadership role in embracing AI for the benefit of Australians while ensuring safe and ethical use. It's not on my slide, but very fortuitously yesterday, the Australian government also launched the AI plan for the Australian Public Service. So it is aimed at guiding safe, responsible and coordinated adoption of AI and to drive the uptake of AI across government. It's built on 3 pillars, and it was interesting having a look at the documentation this morning in regards to some of the conversations that were had yesterday. So those 3 pillars are trust, people and tools. And it recognises that uplifting AI maturity across government will improve service delivery, policy outcomes and productivity, while also maintaining public trust. And it's very much, the policy is very much built on public trust. We're doing quite a bit of work in the legal assistance sector. So Australia is a federal system, which complicates things. We have 8 states and territories as well as a federal system. We have justice systems in each of those. We have courts in each of those. We have legal assistance providers. And legal aid for us is spread across a range of different providers, from community, grassroots level legal services to legal aid commissions to Aboriginal legal services that support our First Nations communities. And like I'm sure many other countries in the room, we are still on a journey of collecting, analysing and using effective data to inform access to justice and our relevant investments. And more often than not, again, I'm sure others can relate to, investment is prioritised in frontline service delivery, and tight budgetary environments can sometimes limit investment in data systems and capabilities, and we're constantly battling with that. As part of this journey, all Australian federal, state and territory governments agreed last year a National Access to Justice partnership, and that commenced in July this year. And what that partnership will do is see all governments working closely with our legal aid sector to co-design a clear framework that will unlock the value of data, build shared evidence on what works to remove barriers to access to justice, and deliver people-centred services to those in need. Now, I've got 2 things on my slide, but I'll just talk to 4 very quickly. The National Legal Assistance Data Strategy will enhance data knowledge and capabilities across the sector and governments. It's going to create a reliable evidence base to guide service delivery, policy and evaluation, but also explore better use of administrative data, user experience, and really build in and embed how we use AI to improve legal problem solving. There's the National Legal Assistance Outcomes Framework that includes outcomes and indicators and data requirements to demonstrate the impact of legal assistance services on clients and communities. Those will be complemented. Our Australian Bureau of Statistics is creating a national legal assistance data set, which will use unit-level data from across the sector. It'll enable detailed qualitative and quantitative analysis that offers a clearer understanding of client experience that will then support evidence-based policy making, but also resolve some of the data quality and consistency issues that we have across our sector. And then the final piece to that is we are investing in the development of a national data repository, which will provide a robust, scalable and secure process for the collection, assuring, cleansing and storing of data, which will then produce dashboards and reporting that can continue to help build our knowledge. I was going to just touch on 2 examples of how we're using data. One is an AI example, because what would this discussion be without an AI example? Justice Connect is an Australian not-for-profit organisation that connects people with free legal help and designs and delivers high-impact interventions to increase access to legal support and progress social justice. Now, Justice Connect has built a justice-specific AI model to transform how people access legal help. It's developed high-quality training data set based on over 20,000 real help seeker inquiries, tagged by 350 lawyers and generating more than 300,000 highlights. And Justice Connect has collaborated with the University of Melbourne to create and train an AI model to understand how people describe legal problems in their own words rather than in technical legal terms. And what that then does, it's powered a intake and triage system. So it analyses a person's description of their issue and then suggests the most relevant area of law to match that person with the right legal service or referral pathway. So it's reduced manual triage time, improved accuracy across legal areas, but also increased the number of people who've been successfully connected with the legal help that they need. It's faster, it's more inclusive, and it's a people-centred intake experience. And it's really blended human expertise with responsible AI to scale access to justice. The final example I will just give, which is non-AI related, is a legal needs body of work, and again, using data to really understand the legal needs of clients. So the Victorian Law Foundation is expanding on a 2023 Public Understanding of Law, or PULSE survey. And they've recently developed papers, extra papers, so they started the process in 2023 and they're just really building on this, looking at the prevalence, impact and outcomes of family law matters. And it's taking an in-depth analysis of people experiencing family law problems, looking at their demographic data, so gender, cultural background, income, types of family problems, and the findings are then informing both policy development but also service delivery by legal aid providers. And the foundation is developing a foundational data mapping project to really understand what works effectively to meet legal need, and that's due to be delivered in 2026. And I'll just put in a plug because they asked me to, but the Victoria Law Foundation will be hosting an International Access to Justice Forum in Melbourne with the University of Melbourne in October next year. And if there's a link there, if you Google that, you will find it. So thank you very much.
Thank you very much. I want to stress two ideas that you say, that is the necessity to coordinate the things with the National Statistical Institute, because sometimes we talk with the same word, but we don't understand the same. So it's necessary to have a common ground, and that is great because you can build a data repository with the same framework for all the institutions, and it's quite important. I think we can talk something about that with our next speaker. And just the citizen focus project like Justice Connect, or the identifying the service for families is quite impressive. Thank you very much. We talk right now with our next speaker is Adrián Franco Barrios. We are speaking Spanish in this moment. Él es el vicepresidente a cargo de...
He is the vice chair in charge of the National Subsystem for Public Safety, Security, and Justice Administration of INECE, the National Institute for Statistics in Mexico. This is a constitutional body of high relevance and importance in the institutional structure of the country. And speaking of data, who better to tell us about data than the head of the National Statistics System to tell us how this can be applied to the justice sector? Well, thank you very much. Well, first of all, good day to one and all. Good day, Nicholas, Esther. It's been a pleasure. First of all, I would like to acknowledge the OECD and the Ministry of Justice in Spain for organizing this space for dialogue, where the highest risk we're taking is learning from one another. I am definitely pleased and honored to be here with you. Well, there are some fundamental rules in the justice system, or even in the security and justice system in each country, and it is the fact that we need to be data-based. It is no longer an option as it was 15 years ago when we thought we could be data-based. Imagine that 15 years ago, I went to the UN Statistics Committee. They meet every day around February or March, grouping 190 countries and all of their statistics institutes. And the first thing we discuss there is the need for governance and justice systems to be part of their agenda. A UN Statistics Committee, we've been insisting on that for over 50 years, and we had never gone into governance, security, justice/corruption. So we went to the UN to suggest that these were interesting topics. So spaces were created in the big UN charters in their buildings to include this statistics department. And just as citizen-centered justice, we also insisted in the use of technologies like AI, which has become the norm and not the exception. So, data rule. I will give you a very short overview of a very broad topic, as Aitor has mentioned. Mexico is also a federal republic. We have a national government, 32 independent states, and 2,470 municipalities, each of which is independent from the next. There is no dependence between states and municipalities, so we have approximately 1,400 police bodies beyond the national judicial power. We have one judicial system for each state. We have justice systems in municipalities. So the institutional structure is highly complex. And the data ecosystem, we don't have a couple of trees. We have a forest, but this is a moving forest. For years, and by institutional design, the Mexican Constitution states two things. One, all public policies are to be data-based. And data-based public policies must be reflected in the National Institute for Statistics. It's in our Constitution. And our Constitution also states that the statistics design is independent and autonomous as it coordinates all instances of the state, from the very presidency to the last municipality. And it's the only autonomous statistics institute out of the 190 that are part of the UN. Since then, and by design, the National Institute of Statistics acts as an umbrella to all these organizations and instances. 80% of my office time as a vice chair is time I spent talking to ministries of justice, attorneys, prosecutors, state governors, the presidency of the republic, because that's a kind of, we are the interaction hub. So my conversations within this whole ecosystem varies depending on the local institutions. But the first thing we tell them, and this is a story that has been around for 15 years. So we're going to check three sources. Your administrative resources. Every day you're generating decisions and records. In other words, case data. As Nicholas was saying, each case contains plenty of data points. So 15 years ago, we were collecting the data in hard copy. We went over these papers and generated data to ingest them into large databases that we compiled. But then automation arrived to create large data repositories in the Institute to process data that are never streamlined. Everything is heterogeneous. We have 32 different criminal codes for each of the different states, stating different ways of contemplating crimes, sentences, processes. 32 different criminal codes, 32 different codes of violence against women, 32 different constitutions, and the national constitution on top of it. So we needed to streamline something that is by nature heterogeneous. Many experiences can be related about that. We gathered the data from all cases across the country. We put the data together, we run an analysis, and then the first question we got was, oh, the data from my court are great. Where did you get them from? Well, it's your data. So the first thing we need to teach the justice system and each court is to work with their own data and figure out their own information. So trying to unify diverse sources is done via population, for instance, census. We run censa of justice. So we create accounts for justice administration and public security and in the criminal system, because obviously a government needs to know their institutional capabilities available to the general attorney, the government, the police force, or their education level, the number of judges and magistrates in the countries, how legal powers are made up, because we need to check for performance. How good is the performance for every 100,000 inhabitants? So this gives us a bird's eye view of our national capabilities, and obviously we can produce a general picture of all legal powers, and this can only be done through a general census. Well, of course, that makes data comparable both in time and space. Unless we have a clear, consistent picture in space and time, we cannot tell if we're doing better or worse than we did in the past. So the Mexican state is making an investment in statistics. So by doing science, because statistics is a science, we work with institutions to offer that general picture. And last but not least, surveys. There are all sorts of surveys, but basically, a survey in terms of security and justice has a dual purpose: understanding the experience of citizens, and second, provide a solution to them by understanding their perspective. And both targets are compatible and can be added to get a better perspective on things. For instance, I can mention one out of the 15 surveys we run that is used in Mexico. This survey includes 110 fields. It's about domestic violence, and it includes a field where the verbatim examples or description of the victims of this kind of violence. Why do we ask that? Well, because if we leave that up to the judge or the court, well, obviously, they also become a party in the procedure. So we run these surveys and then make them available to courts so that they can understand how the experience feels when the victims go to a court of law. Also, we also run the OSB survey on trust. It's a subjective survey, if you will. It's about the perception of citizens about the courts of law and the police. So, do they trust these institutions? Do they rely on them, depending on which places? We also measure performance in our surveys, and also whether or not people had some experience of corruption in any of those instances. That's very important for us to collect. And this is public data, disaggregated for the 32 states in the nation so that each institution can have a true image of the data. So what do we do with this data beyond just publishing it? Well, we work with justice institutions. There are quarterly meetings for all 32 courts of law in Mexico. Much as in Spain, unlike yourselves, I'm not a lawyer, I'm a statistician. So I talk to the justice systems in the 32 states, I talk to them, and they express their concerns. For instance, they ask me, why do citizens no longer trust the work I do? Why do we have this or that level of corruption? Why is our performance going down? Why this and why that? And we have to help them in that process because it helps them do better. Also, as part of the process, we can help them understand about interoperability between their databases and a database in a different area. During the introduction, Aitor was saying that justice institutions are related to hospitals. We gather data from hospitals. Police stations, traffic stations, and we connect all that information and hand it back to them. Because the justice need to see how interoperable their databases are with those of other institutions. And of course, we help them make evidence-based decisions. But most of all, it's very important for us to teach our users to rely or to base their decisions on statistics for control, for assessment. Things as simple as requesting a budget from the legislative power, because ultimately the legislative power in each state decides the size of the budget for that state. So, how does the Supreme Court or a regional court request a budget from the national executive? How do they request greater staff? Well, by using our data. If the population is growing in your state, you have more conflict, and then you need to request more people. Otherwise, you're lagging behind the society you're supposed to serve. So sharing data is of the utmost importance to create these statistics that will allow us to serve better and create data-based justice systems. Thank you very much for listening.
Muchísimas gracias, Adrián. Tenemos unos minutos para...
We still have some minutes for questions. I urge you to ask questions. Sometimes what is most interesting is the reflections and questions from the audience.
A couple of things that you told before. I think it's quite important to teach the public directive and the politician to work with data. As Nick told before, he wake up and see the data and let's see if today is a happy day or a not so happy day. And that's important because many decision-making persons are working by feelings, and we should work based in data, because data is the reality, it's not our feeling. And I think that is quite important to teach everybody, because it's amazing that you have data from an organization and the organization doesn't know that they have that data. And another thing that is quite important is the interoperability and the quality of data. As you told before, let's put an example in justice. We share information of criminal record in Europe among the different countries. But obviously, here in Spain, and Hurto is a very little death, but without violence, even you don't notice about the death. It's absolutely different from a death with violence. we have this kind of different data, but other countries doesn't. What happened? We share information, and maybe in one country they put a very, very strong fee or problem of stay in prison because of nothing. And so it's so important to have a set of data more or less equivalent in different areas. That is not only justice, police, and it's also among countries. And we are living in a more global environment. So OECD and this multilateral session is quite important because we have to speak more or less about the same, because sometimes data seems to be similar, but it is absolutely different. So we need to share the information in a common data basis. Let's see if someone wants to speak. Please raise your hand, okay? They will do. Please present yourself, introduce yourself, your organization, and ask the question, okay?
Sorry, Martin Gromadic of HIU. Nick said that it's so important that the value of data and knowledge derived from this data is shared from the very top to the very bottom. And we all know how difficult, challenging it is in the justice sector. So I was wondering if you can share some advice from your practice and your insights, how to achieve this uniformity of understanding the value from the very top to the very bottom. Thanks.
Yeah, so I was talking both about data, but also about how you affect sort of user-focused change across systems. And so there's a question about implementation, which I'll start with first, which is unless you have a line of sight right to the user, right to the people that think they're designing the great new system or owning it or financing it, you'll find that you get that design wrong and implement it in the wrong way. So we've discovered that user-focused design is brilliant, but you can over-focus on the user, right? So I don't mean you should focus less on the user, but understanding who will interact with both the user and that user's data all the way back up the chain is really, really important because they facilitate making it work. And it's the same with data. So if you've got very different understandings of how important certain bits of data are, people won't curate it in the same way, and systems only do so much. So people have to understand, by affecting this process or making sure that this piece of our architecture works well, is really important because the end result is we get insight into, family life or what a good family resolution is. So yes, they need that shared appreciation in the data, and also one of the things with real-time data that you often get wrong is everyone these days expects everything to be available at all times, and it's simply not. Particularly it's not if you're trying to make sure things are of really good quality. So again, having that expectation where people know what they can expect, on what time period, to what degree of quality, is really important in terms of not disappointing people, if that makes sense. And there's no way to shortcut that. So we've invested a lot in boards and all this sort of stuff, but there has to be a lot of communication a lot of the time.
Hello, I'm Andrew Pillier. I'm a law professor from Thompson Rivers University in Canada. I had a question for all of you, but Esther, I noticed that you spoke about the Pulse report in Australia, and Adrienne, I think you were talking about census and survey information and data. I'm curious to hear your thoughts on the role, if we have administrative data that's created sort of within the system from system users, what's the value of going outside the system and asking people who maybe haven't come into contact with this justice system or don't come into contact enough? How can that or does that inform policy making in a people-centered way?
Thank you. So it's true. We have all of the administrative data that we get from our service providers. Which gives you a really good indication of the types of people who are getting legal services and what their needs are. There continues, though, to be that gap in understanding the people who are not receiving legal assistance. And some really interesting research comes out of that, though, and a lot of the time what the legal needs research finds is that people aren't always going to legal services. So there is that real gap in what we know about the people who are receiving legal services, and then the people who aren't necessarily receiving legal services, but they're resolving their problems anyway. And look, I don't think we've perfected what we then do with that. I think some of the things we do look at is how do we integrate legal and non-legal service providers within those services so that people can access advice that has a spectrum or a scale of managing often their social problems and preventing them getting to the legal need state. But it's a really important question. It's a really important body of work that we're still working on, of how you pair those two things together to inform public policy but also service delivery. And in Australia, and I'm sure elsewhere, we're still grappling with how you ensure that those social services that meet people's social needs also understand that sometimes they are legal problems and refer and direct people in the right way. And again, that Justice Connect example that I gave, helping people to be able to direct them triage them in the right direction by entering in what's going on for them, is another tool that sort of bridges the gap between unmet legal need, where someone doesn't realise they necessarily have a legal problem, and actually a legal service and support.
In the case of us in Mexico, when we talk about surveys dealing with perception and experience, of course, because of the size of the sample, and of course, and the diversity of the different services that the judicial institutions are providing to population, we don't ask in all the cases. We first ask to the people if they identify or if they have been in contact with the institutions, and we give some examples of this. Of course, we can get the list of the people who has been directly in contact or has received some services, but we prefer, besides those lists, we prefer to do the surveys in households. So we ask first to them if they identify, and second one, if they have been in contact or they received some services, and then we ask about them, how was the services, if they accomplished all you wanted, you needed, the time, the quality of service, even the experience of corruption, or so many other experiences and perceptions first. So in that way, we assure that not a person who doesn't identify the judicial institution, they say, well, it's very bad or it's very good. No, we discharge those people, and we focus the data on the people who already have experience with institutions of justice. So, and this is very important, and we give this data exactly to the institutions that are in charge in that jurisdiction. It means we don't mix. We do the national data, but of course we gave this data to the specific jurisdiction.
Thank you very much. Thank you, all of you, because this is a wonderful panel, but we are running out of time. We have no more time for this panel. I want to stress the importance of the data-driven justice system. There are a lot of opportunities, but there are some challenges, some risk about data. So as we don't have a person reading a document, is only data, we have to be quite quality data, so be stressed that thing. If you want more insights, there will be an upcoming publication of the OECD towards future-ready justice, enable data-driven, automated, and artificial intelligence enhanced justice system. We recommend this publication that we will publish in a few months. Thank you very much. Thank you very much. Goodbye.
Thank you very much. It is now getting close to lunch. You must all be hungry. But let me send you off with some thoughts that are kind of out there. First, I think we're zooming in very clearly on the what. That it's about formal justice systems, it's about informal justice, it really is. It's about prevention, it's about resolution, it's about trust, and I think Richard's metaphor of the hole in the wall is a really good one to take with us. I think on AI, we're kind of saying, yes, this is really important, but with some trepidation and a lot of stuff that needs to be done, and a lot of systemic stuff that needs to be done. But I was at least very happy that we didn't have a panel full of lawyers expressing grave concern about AI and that you shouldn't use it. Then on data, clearly, everybody keeps stressing how important it is, but it is critical that you get it right in terms of the quality and everything. And the last thing that really emerges from this is that, my God, when I was young, long time ago, you did a law degree, and then you went to do law stuff. And what's emerging from this panel is that that's out of the window. The complexity of things that need to be done. We need people like you, Margaret, who know about AI, who know about coding, who know about data, who know about the kind of things that you were saying, Javier. We need to think differently about resources, about capacity. I hope some people from universities are really worried now about how to train new lawyers. Let's take that into lunch, and we'll see each other at 3:15. Thank you.
We now invite you to the luncheon pause. Please proceed to the designated area in the foyer outside the auditorium.
Les invitamos ahora a la pausa para la comida. Pueden dirigirse a la zona asignada en la antesala del auditorio.